gone. But nonetheless, Mr. Speaker, Honorable Njomo asked KRA to confirm that PPEs are still subject to 25% import duty, and why KRA's Simba system is classifying PPEs under a new tariff code 6307.90 and therefore calling for 0% VAT but 25% import duty on PPEs. KRA responded as follows to the issues raised in the statement: to confirm that PPEs are still subject to 25% import duty between January 2019 and March 2020, and whether the farms are tax compliant, and if not, why. The correlation between the quantities of empty bottles. Speaker, the rest of the details are there, and Honorable Kajwang has the statement. Whether the said firms and their directors have been involved in tax evasion in the past, the authority is conducting an in-depth audit on the companies and their directors, and the findings of the investigation and audits has indicated non-compliance. For platinum distillers, the tax evaded was 479 million, resulting from undeclared volumes and stamp usage. The action taken is directors have been charged in court. Case at Makadara, case file is indicated there. Assessment and demand of taxes done, 134 million conceded and 90 million paid. Balance appealed. Two Cousins Distillers also has the details. Africa Spirits, the details are there. Keroche Breweries, the details are there as well. The measures that have been taken to ensure that all importers of such consignment pay necessary taxes, the authority has put in place several measures as indicated in the document, Mr. Speaker. The document is very clear, Mr. Speaker. We will sit here and we have much more pressing matters. So, Mr. Speaker, I will just ask the Honorable Kajwang to go through the details that have been provided. To Honorable Owen Bayer, regarding disbursement of equalization fund, these were the responses. In terms of unutilized funds for the period 2015 to 2020, disbursement of funds made from equalization fund to date are based on the first policy on marginalization, which identified 14 counties. The policy also recommended the criteria for sharing the revenue among the 14 counties. So in 2014-15, 400 million was disbursed. 2015-16, 6 billion. 2016-17, 6 billion, bringing the total to 12 billion, 400 million. The total amount expended for project implementation since inception of the equalization fund is only 2 billion. This means that there is a balance of 9.9 billion that is yet to be expended. So why has the National Treasury failed to disburse the equalization fund? The National Treasury has not been able to disburse the funds due to High Court ruling that quashed the guidelines on administration of the equalization fund. So when is the National Treasury expected to disburse the next disbursement? I think the long and short of the answer there is that they are working on regulations as per the requirement of the court order. Thank you, Mr. Speaker. I have summarized as much as I could. Thank you.
Now, the people who sought these requests, some of them are extremely detailed, and I don't know whether the Honorable TJ.
Mr. Speaker, sir, I'm satisfied with the responses I've got from this chair. And may I congratulate the chair of this committee. Looks like this committee was waiting for a competent chair, as we now do. Because as we say, what a man can do, a woman can do better. But Mr. Chairman, I'm impressed that because of this query, KRA has gone back to its investigative and compliance checks, and you now see that several companies have been netted to a tune of more than $1 billion in terms of taxes evaded, and it has resulted in directors being charged before courts of law, and we have details of those prosecutions and in respect of places where they have been taken, and this is very laudable. However, Mr. Speaker, the minister, I think, did not address himself sufficiently to question number Roman 2, the correlation between empty bottles and cups, bottle tops. That is very novel, and we were doing that. I was doing that very advisedly, because the rancor in my constituency, as I said here before in Ruaraka, this liquor that we are complaining about is often cheap liquor. And what the instructions which I had from Ruaraka that I was prosecuting is that you find that distributors and distillers will use the bottles, but after using the bottles, they regurgitate, they use the same bottles again in recycle, using sometimes very dangerous substance, including ethanol. The only way you can be able to get these people is when they declare themselves for tax. And so you need to know how many bottles per a company related to the bottle tops. Because bottle tops, Mr. Speaker, sir, you know, when I talk about these issues, the member for Suba South is unable to understand me, because the man feasts on water and water alone. And so he does not know how these issues sometimes affect some of us. But, Mr. Speaker, sir, you and I, we understand these things. So that, Mr. Speaker, the bottle tops are the ones which are draw taxes. So if you then can relate the two, then you are, for example, able to show that this company is involved in prudent production of what it is. Now, what you see here, I have information, very detailed information, about the bottle tops. I mean, about the bottles, empty bottles. I do have, it is here. But I don't have information on the bottle tops. So I would ask, with a lot of respect to the chair of the committee, that they would ask for a supplementary. It's not quite a supplementary, it's a clarification. That we get information on bottle tops, that then we can relate to the empty bottles, that then our issues can be prosecuted. Mr. Speaker, sir, you saw it the other day in a place called Dindiri, outside Ruaka here, a place which my friend, the Honorable, the Vice Chair of the new Vice Chair of that committee knows. And also in, I think, Gatundu. Members of the public are out there, particularly women, crying about cheap liquor. Even during this time when COVID, and you know, His Excellency, the President, should take a lot of, we cry that we cannot close some of these substances forever. But he did close this thing since February. But even when, during this COVID period that liquor has been closed, you still find mothers there crying that there is a lot of illicit drink. And I think it is also related to COVID. But I will say that for my purposes, I would wish that in Ruaraka, young people, men and women, are able to drink proper liquid, which is certified as spirit, and maji, water which is blessed. I didn't want to turn into Swahili and say maji haramu, but I wanted to say that it is water which is blessed, because blessed by KRA and blessed by the yes. So that this concerns us in Ruaraka, because otherwise you get young people indulging in illicit brews and so on, which is a big problem in our work industry. I thank you, Mr. Speaker, for the response I have, except for those amendments that the chair can look at. Thank you very much.
Member for Soy.
And gets them out of the market. the not being able to account for that fund. And so, Mr. Speaker, I want to ask the chair to, going forward, hold the Treasury to account. When they disburse these special funds, they should retain accountability responsibility. So they should not be passing the buck to agencies. It is their duty to follow through and ensure that the funds that are disbursed to various agencies are spent prudently and there is value for that money. And Mr. Speaker, I wanted to answer Honorable Kositanyi, if he was here, that the reason why pending bills become part of COVID funds is because of spurring economic growth. Mr. Speaker, we realize, and this House, we passed a resolution after the President made a pronouncement that all pending bills must be settled to help the economy to grow. So he was wondering what COVID funds is doing in pending bills. It's because he's pending.
That I believe that although the CJ has advised the President to dissolve Parliament, that particular advice should not be adopted. It should not be adopted for a number of reasons, Mr. Speaker. First of all, there is no timeline. And therefore, we can use that time to prudently examine what is to happen. The reason it should not be adopted is this. If you look carefully at our Constitution, all the elections are lumped together on the same day. The President is to be elected on the same day when the governors are being elected, when members of Parliament are being elected, when MCAs are being elected. And all of them use the same day of the general election, and the date is given. Any consequence, in my view, of dissolving Parliament must of necessity dissolve all those other bodies, including the presidency as elected. And that then would mean that we would not just be talking of a crisis of Parliament, we'll be talking of a crisis of all other institutions. And then we come to the second bigger difficulty. If that is to be so, for the President who is serving his second term, for the governors who are serving their second term, and who by the Constitution would be barred from further running, for this particular one, will they be eligible or not? That is a constitutional question that must be determined beyond just advising the President to dissolve Parliament. We are in even further problems as we speak today. The IEBC is not properly constituted. The Justice and Legal Affairs Committee only considered the draft bill, which is yet to be presented, on how to appoint further commissioners of the IEBC. Which IEBC will be able to conduct those elections in their immenseness to the satisfaction of the Constitution? So, Mr. Speaker, I find that we are in a situation where what was intended to be solved ends up being a much smaller constitutional issue than what then will be created, because we would have to determine whether they are eligible. That is why, Mr. Speaker, I support the Parliamentary Service Commission. I support the move to go to court for further interpretations. We must have that further interpretation clearly before we rush on the issue of dissolution. Mr. Speaker, I have urged 3 weeks ago the leadership of this House that there's also something else we can do in the meantime, even in that meantime. The problem here with Article 262 is the timeline, that we were unable to pass the legislation within 6 years. I suggested, and I still want to suggest to the leadership, that we can consider amending Article 262 and simply move from the 6 years to 10 years. The whole issue will have gone away. And we do not even need a referendum for that, or 15, or whatever the case. Mr. Speaker, I want to suggest, as I close, Mr. Speaker, as I close, that is the discretion of members. Mr. Speaker, I want to suggest that these are the kind of issues that are ideal to be considered in a referendum when you are amending the Constitution. And especially when we understand from the Honorable, His Excellency, the President and the Prime Minister, that the BBI report is about to be released. That would be a good occasion to consider the depth of these matters. If you were to take that advice now, Mr. Speaker, will plunge into a deeper constitutional crisis. Therefore, my view, Mr. Speaker, is that advice, well-meaning as it might be, is advice that should not be taken because we'll be in a crisis. Thank you, Mr. Speaker.
Do I say Honorable Duale wants to weigh in?
Mr. Speaker, I also want to confirm after your statement, the Parliamentary Service Commission, that there is no danger. But Mr. Speaker, with me, Honorable Kainan, Honorable Bandi, those of us who are in the 10th Parliament, I want to take the country and Honorable Kioni the memory line. In the 10th Parliament, this matter was brought to the floor of the House by the then Minister for Justice and Constitutional Affairs, the Honorable Mada Karua. And it was rejected. We were only 212. And later, in the 10th Parliament, the late Minister for Justice and Constitutional Affairs, Honorable Mutura Kilonzo, brought it to this House, to the 10th Parliament. It was rejected. Myself, as the leader of former leader majority, in the 11th Parliament, I tried twice. And the Speaker, parliaments world over, any jurisdiction, at the end of every question, the question will be put to members. Either the nays or the ayes will have it. Speaker, I looked at the House of Congress, our counterparts in a presidential system. If you look at the House of Representatives, the Congress in the US, today they are 23%, 23.7%. Before that, they were stuck at 19.1% in terms of gender representation. Mr. Speaker, the Chief Justice, based on Article 1, Sub-Article 3 of the Constitution, I was elected by the people of Gladys Township, and a Chief Justice or a President, by a stroke of a pen, cannot declare my seat vacant. That is as clear as that. It is not the Chief Justice who voted for me. And the Speaker, those of us who are in the 10th Parliament, this matter, I wish Honorable Sophia was in that committee, parliamentary committee. Speaker, if you look at Article 1, Sub-Article 3 of the Constitution, delegates the sovereignty power of the people to, among others, Parliament. Further, if you read Article 94, Sub-Article 2 of the Constitution, clearly again indicates that Parliament represents the will of the people. We sit here, we represent the will of the people. The Chief Justice himself cannot become a Chief Justice without a due diligence process of this House. The Speaker, if you look at Article 94.1, it also confers the legislative authority on Parliament, and that authority is derived from the people. The people who woke up at 5, who voted for all of us. So, Speaker, my advice first to members of this House is that a time will come when we must have a unity of purpose. We must have a unity of purpose. Even if you don't talk to your women rep, even if you don't talk to your colleague, a time will come. The judiciary have a unity of purpose. The executive have a unity of purpose. But the legislature, over a period of time, didn't have a unity of purpose. Mr. Speaker, go to the House of Commons, and this is the time. In fact, Honorable Otieno Omolo, we are not, why should we bother with the extension of 1520? We will delete Section 2. We will delete, yes. Mr. Speaker, the effect of the advisory. Mr. Speaker, the effect of the dissolution of Parliament, Mr. Speaker, if we are talking about...
Now, you...
Mr. Speaker should be heard.
Order, members. The Honorable Emilio Odhiambo, you seem to have forgotten suddenly that we are in the House. You have not yet been sent home. So just relax.
Mr. Speaker, the effect of the dissolution of Parliament as contemplated in Article 261, subsection 7, could be to prematurely cut short the term of Parliament, thereby precipitating a general election. Mr. Speaker, I read some lawyers, including the President of the Law Society of Kenya, by taking the legislature back to election, it is not a by-election, it is a general election. A general election, it is when the House goes full swing to an election. It is not a by-election. And now if we go to a general election, Mr. Speaker, the only general election contemplated in the Constitution is in Article 101(1) of the Constitution. And that says the second Tuesday of August every 5 years, there will be a general election. And that applies to the President in the reading of Article 136. It applies to governors in the reading of Article 180. It applies to county assembly members within the reading of Article 177. And Mr. Speaker, you know there's a difference between intelligence and wisdom. And that is why I tell people, former Chief Justice Willie Mutunga was a man who has been misunderstood. He was a man with a lot of wisdom. And I'm sure wherever he is, he could not have done this. There are things that you do, even if the Constitution is explicit, but you must look at other factors. Public interest, wisdom. There must be wisdom. And I think with a lot of respect, I don't want to discuss the conduct of the Chief Justice, because he has, within the reading of Article 261(7), he has followed. But Mr. Speaker, the Chief Justice must answer the following questions. And I'm happy we are going to court. We are going to look for interpretation. The Chief Justice is the President of the Supreme Court, which is violation of that gender principle. Himself. The other head of the executive, the President, is in violation of the same principle. And we are three arms of government: the legislature, the judiciary, and the executive. So, Speaker, that's why I'm saying the Chief Justice should have, does the Constitution envisage another form of election other than the general election held on the second Tuesday in August of every 5 years, as envisaged under Article 101 of the Constitution? The Speaker, I have been elected to this August House 3 times. The people who elect me most, my loyal supporters, are women. And every weekend I go to Garissa. And the women of Garissa Township, they don't know anything about this 2/3 gender principle. They don't know. Mr. Speaker, I must be heard as a member for Garissa Township. The Speaker, even this weekend I will go. Last night they asked me, if you listen to the vernacular, last night the women in my constituency asked me, why is Parliament? I am the member for Kisumu, must know that I am a ranking member and I'm the member for Garissa Township. I am no longer a leader. Mr. Speaker, progressively. Speaker, progressively, and you said it on TV, progressively from the 10th Parliament to the 12th Parliament, the number of women leaders have been increasing. Honorable Minnie Odhiambo is a classical example. She won twice. Honorable Sophia is here from the most, conservative constituency. Honorable Sophia, Honorable Shaban, they're here. Mr. Speaker, we cannot create a constitution that gives free seat to one gender. We cannot. Unless we agree as a country, we change our electoral system and we go on party list. If we go on party list, if we go the Rwanda way, then we can talk about it. But as long as you come to this house through universal suffrage, If you want to stand in Migoe, in Kipipiri, you must be ready to face with Honorable Kimunya, the leader of majority. If you want to stand in Garissa Township and you're of the opposite gender, prepare to face me. There's nothing for free. So, Mr. Speaker, the other thing I want to raise, which is very, very important, as I conclude, Mr. Speaker, we need unity of purpose as the legislature. And Mr. Speaker, what the Chief Justice has done, and I think there's a man of the many people who were tweeting last night, the Chief Justice, I think what he has done to the President was described very well by an economist by the name David Ndii. He said, Justice Maraga has given the President a grenade when he has removed the pin. That is how, David Ndii tweeted. And the Speaker, this morning, when I prayed my 5:30 prayers, I decided to watch TV. And I listened to, I don't know whether she's around, she was somewhere here, Honorable Boss Sholei, Gladys Boss Sholei. And I want to tell my colleagues here, this matter, you can't blame it on the 12th Parliament. If you are in the 11th Parliament, you saw what I went through myself as the leader of majority. In the 10th Parliament, may his soul rest in peace, Honorable Kainan and Bandi and Kioni will tell me, and Kimunya, what the late Butula Kiloza went through. And the women, in fact, every time we were discussing, the women went to New York. They went to New York. In fact, one time we reached 2008, there were over 32 women who were missing. Mr. Speaker, I think what we should not be bothered by that advisory opinion. We will deal with the way the PSC has done it. Let's continue with our function. But please, when we enter the precinct of Parliament, let us behave when the judges and the magistrates enter within the precinct of the judiciary. There is a unity of purpose. And I can tell you, I am not a lawyer, but my tweets last night, and Honorable Junet, in fact, the only legal man in this country who spoke for this Parliament is the Grand Mullah. We were waiting for Grand Mullah to tweet until 9 p.m. I don't know what he was planning. He was researching. And Grand Mullah, from where I come from, is an authority. The word Mullah means in the Islamic jurisprudence, when there is a contention, you go to that man. So those of us who are members of Parliament from the Muslim areas, we were waiting for the Grand Mullah. And Grand Mullah has put it very well. Honorable Otieno Omolo, I think, doesn't want to offend the judiciary because he's a customer. He's a customer. I'm not a customer. I mean, I don't do business there. But when your job is at stake, you must stand. Our job is at stake. Somebody wants to cut our 5-year term irregularly through a fraudulent means without looking at the Constitution holistically. I have no problem with Article 261, Sub-Article 7, but you must tell me and interpret what do we do with Article 1, Sub-Article 3? What do we do with Article 94, Sub-Article 2? What do we do with Article 94, Sub-Article 1? What do we do with Article 101, Sub-Article 1? What do we do with Article 136, 180, 177? All these articles must be read together for the Chief Justice to make a decision. The Speaker, the Chief Justice cannot just read one article and advise the President. The Speaker, with those many remarks, I want to particularly speak for my constituency, the women of Garissa Township brought me, and the men and the voters, they brought me, they are not aware of what is going on, and I want to confirm to them. I am their member of Parliament until the next member of Parliament for the 13th Parliament is sworn in here. In fact, Honorable Junet is wrong. Under this system, when the next member of parliament is sworn in is when you lose your seat. So until another member for township is sworn in the next election, I don't want to talk about parliament, but I want to speak to Garissa township people. Don't listen to Maraga, he didn't vote for me. I have never seen him in the register of township.
Very well.
In fact, the president is a person I voted for. And I want to tell the president, please don't listen. Don't listen. We have some business to do for government, and we will continue.
Very well. Now, but let's allow everybody to say their bit. There's no need of interrupting anyone. In fact, I think you may wish that under Article 1 or 2, it is a term of parliament.
Activist. We are all activists for our constituents. So the same way I'm also an activist of Suba North and of fishermen, I'm also an activist of gender. And I have no apology for that. Mr. Speaker, I want to say that the Parliament of Kenya has done its bit. We have brought this several bills before this House so many times before, and Parliament has expressed itself. Parliament does not have to express itself only in one direction. Parliament can say a yes, and Parliament can say a no. And Parliament has said a no. And Parliament having said a no, the matter moves to a different authority. And the different authority here is the Chief Justice. Nobody abused Parliament when Parliament made its own decision. The Chief Justice has also made his own decision based on Article 261(7) of the Constitution. And it is nothing personal. So I think if we really want to help this country and this House, let us depersonalize the attacks against the Chief Justice, because he's basically doing his work. He's extricated himself and is finished, and that's why Honorable Tiende is calling him factus officio in this matter. The matter has now gone to the President, who will either decide to dissolve Parliament, or because there is that lapse in the Constitution about timelines, he can choose to dilly-dally. And if he wanted to help Parliament, for instance, he can choose to dilly-dally. But, Mr. Speaker, one of the things that I want to say is this, that let us be very serious the way we deal with this issue as a Parliament. And the reason we want to be serious with it is that we will deal legally, and the Chief Justice has dealt legally, but there is also politics. And once it has gone to the President, none of us can say with authority that they know how the President is going to deal. He can actually dissolve Parliament. And once he dissolves Parliament, you are home. Personally, I'm not scared, and I'm willing to go home, and I'm willing to be elected or be thrown out, because it's not about me. One thing I am very sure about is that even if I'm not elected, somebody from Suba North will be elected. The issue is about standing on principle, and I stand on the principle of gender equality. Mr. Speaker, having said that, I just want to indicate that on my view as a lawyer, people have been talking about what kind of elections can we have. There's general election that I think Honorable Duale has been referring to, because he was saying you need to read. I don't want to recite all the authorities that he's saying about. And there's the by-election that some members have been talking about, and each of them has its own consequences, depending on which one we choose to interpret it by. But, Mr. Speaker, if you look at this article, it actually talks about an election sui generis, which is neither general nor by-election. It would be an election sui generis. And it's not just sui generis for purposes of our own elections, but in the world, because there is no precedent or constitutional precedent from other countries with this provision. It is actually a provision that is very Kenyan. Just like Honorable Tiendo, who sat in the committee, I also have legislative history, and I know why we came up with this. And if we actually go to legislative history, it will show you why we came up with this. And I sat in the Constitutional Implementation Oversight Committee in the 10th Parliament as the Vice Chair. And we actually rushed to ensure that we pass this because of this article in the Constitution. And the reason we are doing that is because we were concerned about Parliament failing, as has been the history in the country, to pass certain laws. Mr. Speaker, let us be sober. I would urge that we come up with a team in this House to look at this matter from a very sober perspective. The only thing I agree with the Honorable Duale is on the issue of unity of purpose. Not because I fear going back home, but because we need to be sober in the manner that we deal with this issue. It is not a men versus women campaign or fight. It is an issue that is of interest to Kenyans. I know very many male members are telling me, and some have been calling me saying, don't support because you are elected. It's not about me as Millie Odhiambo. It's about a principle. And that is why, for instance, Mr. Speaker, that we were having this impasse at the Senate about revenue. And revenue was about minorities and minority communities that are feeling let out. It's the same manner and the same challenges that women face, that persons with disabilities face, that youth face. And when we start using this kind of approach, then we'll cut them out forever, Mr. Speaker. Let us be sober. Let us give a working solution. Mr. Speaker, I would want to say the Parliamentary Service Commission, I don't have a problem with Parliamentary Service Commission going to court because it's actually the right of the Parliamentary Service Commission. But even as the Commission has gone to court, which may buy us some time, let us also be alive to political realities and find a way out, get a small team from among parliamentarians with the diversity.
It should not have taken that long. But the Honorable Millie Odhiambo and many others of our colleagues would know that we have had arguments about whether that is the route to go or we should go the route of amending the Constitution, Article 97 and 98. Honorable Keinan, you wanted to weigh in?
Thank you, Mr. Speaker. Mr. Speaker, I agree with those who say that we need to have unity of purpose. Mr. Speaker, this issue of gender equity has been around since time immemorial. Mr. Speaker, when the CJ of the Republic of Kenya issued that edict, whether it was administrative, whether it was judicial, I do not know. In my mind, what came first to my mind is what happened to this very important principle called national interest. Mr. Speaker, there are certain things that cannot be documented. There are certain things that cannot be written. But in any country, in any civilized country, national interest outweighs any other interest, whether written or unwritten, Mr. Speaker. And Mr. Speaker, we have had just one by-election pending in one constituency called Msambweni. Even the body that is tasked with conducting elections realized that under the circumstances, under the COVID crisis, under this pandemic, holding one special election was difficult. And here somebody comes and says, go back for a general election, because literally what this means is a general election. Mr. Speaker, I've had in many other jurisdictions that there used to be something called judicial gerrymandering. The reason why I say this, Mr. Speaker, is ideally the other two arms of government are supposed to be offshoots of Parliament, and that is what the framers of the current Constitution and Article 1 had in mind. Mr. Speaker, what I see, even the framers of the current Constitution do not want to take an explicit position on the issue of gender equity. You realize, even under the current Constitution, it's like they never wanted to take a position. This issue was referred to the judiciary. They never wanted to take a position. And yet they expected Parliament, which is a product of one man, one vote, to come up with a formula that none of them, whether in the civil society, whether in the judiciary, failed to take a position. And Mr. Speaker, therefore, what this means is that the failures, the individuals or the groups who have failed in the other two arms of government want to reduce Parliament to a punching bag. And Mr. Speaker, this is one thing that we should not accept. This is politics. This is politics. This is politicizing the institution of Parliament. And Mr. Speaker, I want to stand here and say what you did yesterday was the right thing. And even all the other lawyers with sober minds, with all other lawyers, including Grand Mullah, who have expanded their horizon of thinking outside the petty politics of their sectarian interests, Mr. Speaker, have supported your position. And that is the position today we as the PAC. We as the PAC today had a crisis meeting under the leadership of the Speaker and resolved on your behalf to challenge this thing in all the courts possible. And that is the task, and that is the mandate of the PAC. It's not something that we want to do out of the blue, but it's something that has really really something that we really feel that must be done. Because how do you do this? How do you just come up one morning without giving notice to the Speaker of the National Assembly, without giving notice to the Speaker of the Senate, and you just say you have advised the President? I do know the President is also the head of a civilized nation called Kenya. There's national interest. Mr. Speaker, I'm told when you want to become celebrated and you want to be honored by the international players, in particular the international actors, in the name of NGOs, you must do something so radical that you become sensationally covered in the newspapers. And I think this is one thing. So I don't want to discuss the details or the substance of, or the content of what the CJ did. But honestly, if you dissect it, isn't it meant to trigger something else outside the retirement? The pending retirement, and that is the essence. And therefore, Parliament is the easiest institution to use as a punching bag. Please, I want to beg you. It is not about your electability. It is not about whether you will be re-elected or not. It's about this principle of Parliament being used as a punching bag. I was there in the 10th Parliament. I was there in the 11th Parliament. I am here in the 12th Parliament. How comes it failed the attention of all those who are there to sort out this? Why will you attribute it to Parliament? Why do you want to negate the very principle of free and fair election if the people of Eldas decide to have a lady as their representative? They will have it. If they have decided to have Adan Kainan as the representative, then that should not be impaired at any circumstance, Mr. Speaker. And this is why I'm saying, for the sake of this institution, and I know we will not be the last Parliament. We are not the first Parliament. Our Honorable Dali has actually alluded to this. In the 10th Parliament, they tried. Mother Karua was one of the best gender activists. I will say this, equivalent to Mwili. She did. She was a Minister for Justice. She had an opportunity to fix that thing. Actually, the circumstances at that particular time were easier. They didn't do it. They left it to Parliament. It came to 11th Parliament. It didn't happen. It came to 12th Parliament. It started happening. Somebody wants to spoil our image. This is one thing that we must reject. Finally, Mr. Speaker, when a crisis like this, the whole world is right now affected by the COVID crisis. Where will the money to conduct a general election come from? Because we all know where we are right now. And Mr. Speaker, in conclusion, this is not a matter for so and so. Please, let's debate it soberly. Let's approach it soberly so that as a House, we address this issue with our open mind. Thank you, Mr. Speaker.
Take Honorable Wamalwa.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, it is very, very disturbing. I want to quote, Mr. Speaker, what Martin Luther King Jr. said, that the ultimate measure of leadership, Mr. Speaker, is not where one stands in terms of comfort, Mr. Speaker, but where one stands in terms of controversy and challenge like now, Mr. Speaker. Mr. Speaker, I was very affected and perplexed by the ill advice, premature advice from the Chief Justice. Mr. Speaker, why do I say so? We are aware, Mr. Speaker, on this matter of truth and gender. 2017, there was an order that was given by Justice Motivo, Mr. Speaker. And the Chief Justice knows in 2 weeks' time, there is going to be a hearing to determine whether that order is applicable was applicable in the 11th Parliament or in this 12th Parliament. What was the hurry for? That's why, Mr. Speaker, I'm saying it was a challenge. Is it because he's about to retire in 3 months' time, Mr. Speaker? Is it because he wants to go down in Parliament? He wants to go down with BBI, Mr. Speaker? Mr. Speaker, even the Supreme Court itself, those judges, they do not subscribe to the truth and gender rule. And you know that, Mr. Speaker. In the cabinet itself, there's no truth and gender rule, Mr. Speaker. This Parliament has worked extra hard, Mr. Speaker, to achieve this. And the many legislators who are shouting outside there, particularly our female colleagues, they should stop pretending, Mr. Speaker. We've been in this Parliament, and the time of voting when it was here, they were away in New York to gain allowances, Mr. Speaker, as opposed to advancing this. It is really shameful, Mr. Speaker, for those of you, if you push me, I'll mention your names. Because the two-thirds was not achieved because of their selfish interests. This is the time, Mr. Speaker, we want to debate this matter soberly. Some of you who have just come in 12th Parliament, you were not there in the 11th Parliament. And Honorable Wanga was one of the leaders who went to New York at that time, Mr. Speaker. And he's been ahead shouting all over. And we can go and check even the itinerary of the flight. She could not stay here to talk on this matter. Mr. Speaker,
now that you have mentioned Honorable Wanga,
she was among them who went to New York at that time.
Honorable Wanga, what?
Mr. Speaker, I have been here in the 11th Parliament and the 12th Parliament. I have been in this house when Duale 1, Duale 2, Duale 3, and Duale 4 were shot down. I was in this house. And I want to challenge the Honorable Member for Kiminini that he either withdraws his assertion that I was in New York, and to New York I have been, but I have never been in New York at a time when this House is voting on a critical matter as the two-third gender principle. I have been here every time. So, Mr. Speaker, I want to urge you for this, that Honorable Chris Wamalwa either substantiates what he is saying or withdraws that statement. Mr. Speaker, this matter is a matter for all of us. Mr. Speaker, it is for all of us to resolve it together. Mr. Speaker, we will not get to the bottom of it by attacking each other and bad-mouthing each other and trying to put each other down. We will only resolve this matter with the unity of purpose that the Honorable Aden Duale mentioned. So, Mr. Speaker, I would urge you to ask members, even as we debate, to try not to drag each other down, because it is not by pulling each other down that we will find a solution to this very important matter. We have our views on it. It may be different from what the Honorable Wamalwa has, but Mr. Speaker, as you have said, you may not agree with what I say, but you will defend unto your death, Mr. Speaker, as I know you, my right to say it as an elected member of this House, Mr. Speaker. So even if we don't agree, let us not bring each other down, because we all, Chris, you and I need to be somewhere after Nini. Sasa unaleta Nini?
Thank you, Mr. Speaker.
Honorable Wamalwa.
Thank you, Mr. Speaker. Mr. Speaker.
Honorable Wamalwa, please, it is, earlier member, please.
It is
let's not try to spoil the names of one another.
Thank you, Mr. Speaker. Mr. Speaker, this is a House of Records. And if you allow me, I can go to the Hansard, Mr. Speaker, and prove Honorable Wanga wrong. Because I was here and I support the two-third gender, Mr. Speaker. And that's why I was so keen. So you cannot go in the media, Mr. Speaker, shouting loudest, and yet you've contributed to the unsuccessful passage of this bill, Mr. Speaker. That time, if you allow me, I can go to the Hansard and prove it, Mr. Speaker. As I move on, Mr. Speaker.
No, Honorable Wamalwa, it is not personal.
Mr. Speaker, as we move forward, Mr. Speaker, as we've said, this is about unity for purpose, Mr. Speaker. I cannot withdraw. I'll go to the Hansard and substantiate, Mr. Speaker.
You know, Honorable Wamalwa, if you insist on that record, then you'll have to,
Mr. Speaker, under our standing orders,
go down. Yeah, you are responsible for the accuracy of what you say.
Yes.
Yeah. So if you have that answer, please just table it.
Mr. Speaker, if you allow me, within our standing orders is allowed, I can substantiate by going to check our standing orders, particularly at that particular time when that matter was live on the floor of the House. I can substantiate that, Mr. Speaker. Give me time. Okay, we'll discuss when we come to that time. Please allow me to go look at the Hansard.
Honorable Wamalwa, do you have that record? Do you have that record?
The Hansard is there, Mr. Speaker.
No, please.
If you allow me, I'll go to the Hansard. I don't have the Hansard at the moment as I speak.
So you stand by your statement?
Yes, Mr. Speaker.
And now you would have to stop there, yeah, and you've been challenged, because you've been challenged, we will give you the time to go and look for that handstand. And if you don't, other consequences will follow. Yeah? Honorable Wamalwa, you'd have to stop at that point so that you go and look for that record, which you say. Because we can't just let you say the handstand bears me out. We've seen occasions where members have said this and handstand will bear me out. When it is checked, it doesn't bear you out. So until such time as you bring a copy of that handstand, you'd have to.
Mr. Speaker.
The option available is you either withdraw. What's the issue? What's the issue that
Mr. Speaker, I brought an amendment of a bill to change the election date, which had required that supermajority. And I remember that time, Mr. Speaker, because our standing orders allow us. Why don't you give me time? I'll go to the Hansard, Mr. Speaker.
Now you are talking about a different bill.
They came at a similar time, Mr. Speaker, and the requirement was similar.
No. Election date and 2/3 gender rule are different.
Mr. Speaker, this is a House of Records. No. I know, Honorable Wanga, we are supposed to go meet somewhere. God willing. We don't know who will go through. No, but if at all I want to substantiate, why should you force me to withdraw? Our standing orders allow that.
Then go and get the record.
Absolutely. I'll go and get the records, and I'm ready for consequences. Okay, please.
Go bring
we don't
the
want
record.
our colleagues to be pretending, and yet they've contributed to the failure of passage of this bill on this floor of the House, Mr. Speaker.
Please
Mr. Speaker, as we move forward.
No, Honorable Wamalwa, unfortunately, because you don't have that record, and you insist on it, you'll have to stop there, go and get the record, bring it here tomorrow. Yes. Honorable Kioni. Honorable Kioni.
Thank you, Mr. Speaker, for the opportunity to contribute to this. I have nothing personal against the Chief Justice, Mr. Speaker.
So, Honorable Wamalwa, Thursday afternoon, 24th.
But, Mr. Speaker, I have the advisory opinion from the CJ, and some of the words that he has used in the statement indicate different. Because, Mr. Speaker, one of the paragraphs, I think paragraph 24, the CJ seems to accuse us for having been carelessly lazy. Carelessly lazy attitude. That is not a word you'd use if you don't have anything specific against this institution. Mr. Speaker, again on paragraph 26, the CJ again says that Kenyans desire to incentivize the political elites. Mr. Speaker, again, you can actually see something a little personal against the institution of parliament, because if we have to be taught something as the political elites, I think it is going beyond the advice that we have been talking about. Again, Mr. Speaker, paragraph 27, I think he has Songkok. Just take a walk, man.
Honorable Songkok, you don't walk like, you don't do it here. You are moving all over. You are not dealing with wildlife.
Mr. Speaker, this advisory opinion by the CJ has even a typo error. I think it is supposed to have 28 paragraphs. He seems to have repeated paragraph 26 twice. On the second, I think it should be paragraph 27. Again, he has said that we must be held accountable as members of parliament, meaning that, and then he goes ahead to say that we must say no to impunity. I mean, the choice of those words from paragraph 24 all the way to paragraph 28, Mr. Speaker, seems to indicate to me that the CJ or the judiciary has kind of taken an attitude towards us. And I believe that even as we think of how to resolve this issue, it is important that the judiciary also pays attention to this third arm of government, and they need to treat us with the respect that we deserve. To say that we have been carelessly lazy as members of parliament, it's not a kind word to use on people who have been elected. To say that we must say no to impunity, this house is not a house of impunity. It is actually, we have said it over and over again, it's a house of records. To say that we must be held accountable, it is the thing we do every day. So I see an attitude from the Chief Justice that is not really helpful in resolving this issue. And it is, I don't want to go through all the words, but there is, you can actually see even the way that the advisory opinion goes to address our speaker. You can actually say that there is something that, it's like there is something to grade, and I agree with Mheshimiwa Kenan that we may have to look at these things more politically than otherwise. Mr. Speaker, let me say this on the onset as the chairman of CIOC. We will soon be calling the Chief Justice, I hope before he retires, to come before the committee because the judiciary has failed to implement the Constitution and specifically the two-third gender rule. We want him to account to Parliament. Why is it that within judiciary, they have also failed to account on the two-third gender rule? And that is the work. That is the work of the CIOC. We will also be summoning the executive because the committee has been given that mandate by the Constitution to ensure that every institution, including the Office of the Chief Justice, has implemented the two-third gender rule. So, Mr. Speaker, I say this so that we can get it clearly as Kenyans, or Kenyans can get it clearly, that it is not Parliament. It's not just Parliament. And narrowing this issue, and I would really want to ask many of us, narrowing this issue of the two-third gender rule to just within Parliament is a very, you are looking at it in a very shallow manner. I would want us to look at it globally, because that was the intention of the Constitution. And if you go through the laws that were passed during 10th Parliament and 11th Parliament, as required under the 5th schedule, you will see that, Mr. Speaker, many of those acts of Parliament, and I thought those who would care would actually have commended Parliament. I haven't seen a parliamentarians who have passed so many laws within such a short while. 10th and 11th Parliament did a commendable job. But nobody has ever been out there to say that we helped in a make, there is the issue of cost in it. And then finally says, it's a pain that we must be ready to bear. I don't know, it's a pain. And he says, there is no gain without pain. This is not a question of pain. It's really putting us in a crisis. And it's a crisis that once you are in a constitutional crisis, who guarantees you that you are going to get back to normalcy? I mean, any person can decide to become rogue and get us the wrong way. So when you are in that kind of a position, or in that position of authority, don't look for ways of causing people pain. Look for ways of giving solutions and getting us to move forward, not putting the country into a crisis. So, Speaker, I thank you. And I know as members of CIOC, as I mentioned, we will be, with your permission, because the letters must come through your office, we'll be writing to the Chief Justice so that he can also come and account as to why, for now 10 years, he has failed to observe the two-third gender rule within his arm of government. I thank you.
Honorable Mbadi.
Thank you, Mr. Speaker. Mr. Speaker, I want to start by saying that I'm happy that the Chief Justice has invoked Article 261. But my happiness is not informed by the same reasons as Millie Odhiambo. My happiness is informed by other reasons. This is a time for this country to start clearly witnessing and seeing the inconsistencies and contradictions in the 2010 Constitution. Mr. Speaker, when we were pushing for the passage or the enactment of this Constitution, both the nays and the ayes were in agreement that there was about 20% that was not right. The question was, where is this 20%? In fact, I don't know how we calculated and tabulated the 20%, but we all spoke about 20%. Mr. Speaker, now you can see the 20%. Mr. Speaker, I want to give myself as an example. But before saying so, I want to say that our method of electing members to this House, apart from the past the post, it is not proportional representation. That is being practiced in Rwanda and any other jurisdictions that have moved towards realizing this principle. Mr. Speaker, I want to give you an example, and I want to give myself an example. In the last election, at the party primaries of the ODM party, we were 3 candidates. I got 12,498 votes. The second candidate, who was also a man, got 10,726. And the third candidate was a woman. She got 506 votes. In the general election, Mr. Speaker, again, I had an opponent or a competitor, a lady, who only got 273 votes. Mr. Speaker, what the people of Super South said is that they don't mind a man representing them, including women. And in fact, the women voters are over 50% in my constituency. Now you are telling them that an individual, through the provision of Article 261, is telling the people of Super South that they should have elected either the lady who got 506 or the one who got 43, not 73. And that is why I'm being sent back home so that they do another election. Mr. Speaker, there is nothing that can be more unjust than that, Mr. Speaker. Mr. Speaker, the other question I asked myself, and by the way, I've been religiously supporting that we provide a solution to Article 100 and a solution to Article 27 of the Constitution. But the question I've been asking myself, and I was keenly listening to Honorable Tiende Amono. Unfortunately, I think he has left. And he's here. And also Nzamba Gitonga, who gave his opinion. Mr. Speaker, I'm asking myself, the drafters of the 2010 Constitution provided for Article 177 of the Constitution and 178, clearly spelling out how the 2/3 gender principle will be respected at the county assemblies. But, Mr. Speaker, when they came to the national legislation, what did they do? They looked at the Senate and created 16 seats for women. After the 47, which is left to anybody to contest, there are 16 for women, and another 2. One, a youth who is a woman, another one, a person with a disability. 18 seats were specifically created in the Senate for women. My understanding is that this was meant to help achieve or realize the 2/3 gender principle. Now, when they came to National Assembly, Mr. Speaker, they created a seat no one had ever imagined. The 47 women reps. No one ever imagined that there could be a position contested only by women or by any gender in the 47 counties. And we thought that was to realize this principle. Now, why was it so difficult for the people of Kenya to just decide that we want National Assembly to not have more than 2/3 of either gender? And Senate, the same. Why did they come with the provisions as it is in the Constitution? And that is why I think whether we say what, this principle, Mr. Speaker, I want to say it here. However, even if Maraga was to succeed by persuading the president to dissolve parliament, you will dissolve this parliament 1,000 times if you don't address this issue through a referendum, through amendment to the Constitution. you will, in fact, I dare say that if this parliament is dissolved, the next election will bring more men than it is today in this house. And so, Mr. Speaker, and I've heard many of my colleagues saying, let us be sober. I also want to repeat that let us be sober. And by the way, this thing is, the reason why this thing has been failing is because of the attitude of sometimes of our female colleagues. Because when you talk about agenda, they are shouting. And the truth is, Mr. Speaker, I know you challenged Honorable Chris Wamalwa. The truth is that day, there were a good number of women members of parliament who are not in this house. And I even challenged Mr. Speaker, I remember I raised that the list should be published. And Mr. Speaker, you didn't agree with me. Honorable Wamalwa would have not gone to the pains of bringing that list. In fact, that we supported that motion by Duale. I'm the one who seconded him. Religiously have been supporting this gender principle. We have not been having full house of women MPs in this house, Mr. Speaker. Let truth be told. They are the ones who are failing us. I have never failed to be here to vote for this amendment. Most of them have not been here. Many of them. And when you say that, they get agitated. You should not be agitated. If you are elected here to come and represent women issues, please do it. And do it properly. Don't do it out there. It doesn't help. You talking and supporting Maraga will not help. This house is not going anywhere. Who is this mad person who is going to dissolve parliament at this point in time? It is not going to be dissolved. And by the way, Mr. Speaker, the only route to solving this issue is BBI. Yes. That is the only route. We will talk all the language we want to say, but the only route is again to go back to the people of Kenya. In fact, I'm looking at this constitution and I'm seeing the mischief. The drafters, and Honorable Tienda Molo, with all due respect, these drafters became mischievous because this was a hot potato. They didn't want to touch it. They left it. Why did they touch the county assemblies? It is very clear. It is explicit. But for this one, what did they do? If you strictly read this constitution, even that Article 261 that we are talking about, Article 261 is addressing itself to those provisions under the 5th schedule to the Constitution. Yes. And by the way, we were burning midnight oil here. They are only live longer when they are still, when their minds are still sharp than some of us. That is something I've just asked a question. There are positions that I think, if you tell me, Mr. Speaker, the way I'm looking at America, and I'm looking at some countries, I see the president is where we allow wisdom, age going to 70. Thank you, Mr. Speaker.
Well, you're speaking to, I suppose, the provisions of Article 81B, that the electoral system shall ensure that not more than 2/3 of either gender are represented. I don't know whether Parliament has been vested with the power to decide the electoral system, or is it a function of the sovereign to choose the electoral system. Leader Majority.
Thank you, Honorable Speaker. Honorable Speaker, let me start at the outset by congratulating you as the chair of the Parliamentary Service Commission for the statements you made this morning and the advisory you gave members yesterday, which helped to bring down the temperatures that were beginning to be fanned, and the fire that were being fanned by activists all over, saying, almost creating the situation that Parliament is illegitimate. But you've helped, first of all, in terms of reasserting the legitimacy of Parliament and putting facts so that people did not know. The issue here, and I believe the Constitution, when we adopted it, and the clamor for the new Constitution between all the way up to 2010 was all about serving the greater public interest and improvement in the governance of the country. Now, I'll come to that later. But one must ask, on all the issues that have been brought, the quagmire that we are in now is, where is the greater public interest being served? Right now, we are spending this time debating a matter that we need not have debated if the Chief Justice did not do what he did. We would have been passing bills. A lot of energy is being consumed around the country with lots of anxiety and people not sure what will happen next. Staff, these members of parliament, 400 members of parliament, 414, including Senate, each has about 10 members of parliament, 10 members of staff. So collectively, there's 4,000 members of staff who are not sure whether they will be going home or not, and their families, who are now full of anxiety. Are they going home or not? Because once you leave, your constituency office is dissolved. And all those families who are relying on you, the 4,000 families who are relying on members of parliament, will have to go home. So there's a bigger picture that perhaps the CJ may not have looked at. The international community is watching. That's why with activists saying that even decisions that are going to be made by this parliament will be legitimate. Where do you place Kenya in terms of its predictability on policy, on decision making? Because those are some of the fundamental issues that a responsible Chief Justice ought to have looked and said, if I make the decision, what are the bigger implications? It's not just about saying simplistically that 261(7) gives me the right to convey a decision to the president. And if it was so simplistic, it would have been conveyed in 2015, 2017. But the Chief Justice then realized it was not exactly, or perhaps the advisory he had, realized you could not do that. Yet it was perhaps the best time because the election was just around the corner. But here we are with 2 years to go, in the middle of a pandemic, in the middle of financial crunch, in the middle of so many things happening, and all we are thinking of is send one arm of the government off, and then you're not even thinking of when you are off, when you are gone, within the 21 days he thinks we should go, who will appropriate the money for the election? Because you will not be there. Who will even oversight the executive and the judiciary when you don't have one arm of the government in place? But let me ignore those, the pros and cons of his decision, because I believe it's been canvassed and there'll be more people talking about it. Let me come back to that gender rule. So, Speaker, we were with you in Bomas. Certainly, I was there from 2003. Mr. Speaker, you were there even earlier. And with Honorable Shakil and others. And it's a very complex situation because it was not exactly legal. It was a politically expedient decision that was made, and the genesis of it was the composition of the delegates in Bomas. Was from every constituency. There was a member of parliament, there was one woman, and one man. So there was 3 delegates from every constituency. Then there are a few civil society, but also respecting that kind of configuration. And when we sat and we were getting close in the discussions, as part of the negotiations so that Bomas could be passed, it was said, the lady delegates in Bomas said, now that we are 1/3 here,
we also want to be 1/3 in all their positions. That's how the 1/3 came. I mean, it was that simple. That's why it was not 40% or 50%. And I think it's important we go back in history to understand the genesis of some of these things. Now, at that point, in Bomas, then the question became, how do we ensure that we are going to bring 1/3 of the women? Examples were given about Rwanda. Examples were given about Uganda. But the first thing that came out was Uganda is not exactly the democracy. And I'm not saying that as discussing how they operate. Even Rwanda. The autocratic rule determines who stands. It's not exactly the same in Kenya. So figures were, options were battled around. And a clause was included that to ensure that we will have the women, we will have what was referred to then as the mixed member representation. And that we would forget about constituency-based first past the post. We will now go the South African route, where parties will propose, will vie for the seats, and then there will be apportioned seats in parliament. And then they are going to nominate candidates on a zebra system. That's how the first zebra system was being discussed in Bomas. So there will be a man and a woman, in which case, at any one time, when you pick all those things, you ensure that at least 1/3 or even 50% is represented. But when you are in Bomas, the same mixed member representation, which was the anchor of ensuring that this 1/3 is fulfilled, and on which basis it had been included in Article 27, on what basis it had been included in Article 81B, that the electoral system shall ensure that 1/3. Yeah? Members in Bomas said they do not want that kind of system. They all want to elect their person. They want to know that this is Amos Kemunya who are electing for Kibeperi. They don't want to be told that as a party you elected Jubilee with 206, and then the people are taken to them. That is the same basis that they said, even for the chairman of the councils. Remember, the chairman of the councils and the mayors used to be elected by the councillors. They said, even for those, they want to do direct election. That's how governors ended up being directly elected. Because people say they want to feel the person they have elected. It's important you get that history so that you know that this thing, although it had been included, agreed in principle, and 2 articles had been drafted on the understanding that it's a mixed member zebra situation, Article 27.3 and Article 81B. They had been drafted with that in mind. But when the mixed member system of election was dropped, nobody bothered to look and harmonize 27.3 and 81B to now reflect the new situation. At the county level, it was agreed that the 14 functions that have been devolved are so close to the people that it's important to get the people to actually be represented in the decision making. All right? And at that point, there was no debate that at that county, in the wards, at the county level, because of the sensitivity of the issues that have been devolved, the people needed to be represented. Much to do with what the Jefferson was calling the ward republics, right? That get people involved in the decision making at the local level. And at the Senate, it was the same because it was overseeing the local level. That's how the names were included. But in the National Assembly, remember it was supposed to be mixed member because it was not, there's no way you're going to get mixed member in the Senate because the Senate is a person for every county, right? But for Parliament, it was to represent the party, to bring its people. Now, but even in the Senate, the 16 women delegates, the nominees, don't have voting rights on a county issue. But they can vote on all other matters being debated in the Senate, because it was for purposes of other issues to do local level, right? Affecting people at the local level on the 14 devolved functions. Anyway, be that as it may, unfortunately, Bomas did not succeed. 205 was defeated. At 2010, the new constitution, the council, the committee of experts with the harmonized draft and all that, removed some things, tinkered around, but forgot to harmonize the new first past the post with the provisions that had already been included in 27.3 and in 81B. And we are in this quagmire. Article 1 puts the power, the sovereign power of the people to decide on the Kenyan people. It's them to determine who they want to represent them. So, in the absence of the system of voting being included in the Constitution, creating that zebra style, any other you put will be in contradiction to Article 1. I'm not a lawyer, but I was in Bomas. And I followed that discussion. And I followed that discussion ever since. We brought the first amendment here with Mother Karua. I was in this parliament. I was in government. We brought the second amendment with Honorable Mutula, the late Mutula Kilonzo. We were here. And we were told this thing is going nowhere. You are bringing a contradiction between Article 1 and whatever you're trying to bring, whatever article. So, we are in this situation, and I think, members, we need to then figure out how do we ensure the 30%, the 40%, and the advisory that was given in 2015 said it is progressive. It's not just about laws. It's about affirmative action. How do you empower the girl child? How do you empower the women out there to have the power to be able to run for office? So it's a bigger issue. And we cannot achieve it here by just saying that pass a law to actualize a two-thirds gender rule. Yeah? You cannot do that without breaking another one within the Constitution. So as John Buddy says, it's an opportunity we have when we do a comprehensive review of the Constitution to say, do we want mixed member so we can have the zebra situation? Or do we want to then say Kenyans can now afford a bigger parliament with another 80 extra ladies being voted here, yeah, and how it's determined, yeah, to avoid all those issues of people feeling that perhaps it's the wrong thing, so that we can get the parity that we want. But let me not, I think that will happen at some point. And what I would wish is even as we debate on this matter, have 70 plus members of parliament who are ladies in this house. I would like to start a conversation with them so that the 70, we take them to a retreat somewhere. Whether it's for 1 week or 2 weeks or 3 weeks, we lock them there and tell us, give us the solution to how we are going to sort out the two-thirds gender rule. No, it's my proposal. Because at the end of the day, the question that we get asked as men when we go promoting and saying we need more women in parliament, the first question that you are asked, even those who are there, what have they done? We get asked that question. And of course, it's me who is asked. So, but I want to see. I know you've done a lot. That's relative. But be that as it may, Honorable Speaker, I think as a parliament, and I'm sure we have gone through this before, the Committee on Implementation of the Constitution has gone through all the laws that we were supposed to pass. And the only law that was outstanding was the law to actualize Article 100, which this House passed in March. So as far as I'm concerned, there's nothing that was anticipated through 2261(7) that this House has not done. But it's something that perhaps the CJ was obviously ignored, including saying, quoting a law, which we've done, and saying we have not informed him that we've actually done, although we know we have done. So perhaps, so that we just, I don't talk forever, I think the most important thing is going forward, what do we need to do? And on the issue of the gender rule and all that, we have done 100. So people will see whether it's good or not when it comes from Senate. In terms of the constitutional changes, I believe there's a framework that's already in the air through the Building Bridges initiative. Perhaps we need to revisit that and pulling together, not just thinking of BBI as a political thing, but as a vehicle towards changing the laws of this country to actualize the desires of the people at that point. But as a House, we are under threat, and we know. And I started by saying, Mr. Speaker, that we congratulate you for what you did. But even as you go to court, this matter is now in the hands of His Excellency President Uhuru Muigai Kenyatta. And I know we are putting our efforts on the Chief Justice, but we are perhaps forgetting the only person who can ensure sanity in this country for the next 2 years is only the President. And I would like the House that we join together in appealing to the President to consider, as he has always done, the bigger public interest. As he makes that decision, as he reads that advisory, which I'm sure probably was even sent by Twitter or by email, as he considers that decision to apply his conscience to the bigger public interest, to the special circumstances that this country is in, and to avoid giving in to activism. We know he respected the decision of the Chief Justice in 2017 and actually agreed to a repeat of the election because to demonstrate respect for the rule of law. But here, we are not sure is the rule of law being applied. So we would appeal to him to ignore the activism that has been shown and act in that bigger interest and save this country from chaos. There is no way, Mr. Speaker, the solution to a problem can be worse than the problem. And like Solomon, the biblical Solomon, it's time for the President to decide whether to kill the baby or to save the baby. Because that is the situation we are in. And I think as a House, if we get our committed, we are all committed towards that, then we will be saved as a House so we can save this nation and move together. Thank you, Honorable Speaker.
Member for Kisumu Town West.
Mr. Speaker, I need not remind you that it is Kisumu West, not Kisumu Town West. Mr. Speaker, as we debate this issue, I would like the members of the House who are listening to me to know that we need to listen to each other and we need to make sure that His Excellency the President gets the advice that he needs from this House. Before I address that issue, Mr. Speaker, I want to ponder certain questions. Since 2015, the CJ has been quite silent on this issue. And suddenly, he has come up with this advisory. Is it possible that he could be acting at the behest of certain persons who are not in the House? is it possible that he's acting on behalf of persons who would like to scuttle the BBI process? Is it possible that he's not acting alone? Mr. Speaker, I point out these three questions, and I want to address this issue now, not just as a ranking member of this House, but also a ranking member of the LSK and a contemporary of the Chief Justice. Mr. Speaker, what we have that we are discussing today is not a judicial decision of the Supreme Court collectively or the CJ alone. It is simply an advisory, not a judicial decision. Advisory in legal interpretation means consultations. Such a momentous decision cannot be made without consulting the heads of the two other arms of government. Mr. Speaker, the Chief Justice acted recklessly, and I have no qualms about saying so. But now that he has done what he has, it is upon us now to take this opportunity to tell the Chief Justice that his advice is erroneous and wrong, and to tell the President why he must ignore that advice. If we don't do that, then we shall be failing in our duty as members of this House. Article 261, sub-article 7, Mr. Speaker, uses the word advice. But sub-article 7 also says that His Excellency shall dissolve the House. That article and sub-article 7 is self-contradictory. In legal terms, when you have such contradictions in the law, then you look at what is more convenient. Like Honorable Kumuja has just said, are you going to solve a problem by creating a bigger one? Have we addressed that issue? Mr. Speaker, I find it strange that we have not considered that in the absence of this Parliament, and I mean when I say Parliament, National Assembly and the Senate, in their absence, can an election be conducted in this country? Is IBC as it is now properly constituted to conduct an election? Do we have the finances for IBC to do so? If we are going to do that, who is going to appropriate finances to IBC in the absence of Parliament? The decision of the Chief Justice cannot be implemented. It is wrong. But most importantly, Mr. Speaker, Honorable Kumunya has explained the background of how we ended up with what we have in the Constitution. But every cloud has a silver lining. Mr. Speaker, the silver lining on this cloud is that now members of this House have a chance to look at the various contradictions that we have in our Constitution and see how best we can resolve them. The only way to resolve these contradictions that we have in the Constitution is through the BBI process, not by this advisory to the President. Look at Article 267, Mr. Speaker, that gives the Chief Justice the authority to give that advisory. And let us not forget, it is an advisory, not a decision, not an order. Let's look at that article in relation to Article 38(2) of the Constitution. Mr. Speaker, Article 38(2) says as follows. I know you're familiar with it. Political rights. Article 38(2), every citizen has the right to free, fair, and regular elections based on universal suffrage and the free expression of the will of the electors. Clearly, this is one article that contradicts 267. And they are in the same Constitution. And that's why I'm saying that we have the chance now to look at these various contradictions and see how best to resolve them. Mr. Speaker, let us look at Article 259. And 259 is on how we construe the various provisions of the Constitution. Has the Chief Justice complied with that? Did he address his mind to 259 before he issued the advisory? I think not. I think not, Mr. Speaker, because the reading of Article 259 is as follows. If you are going to construe the Constitution, then these are the tenets on which that interpretation must be based. Article 259, construing this Constitution. Sub-Article 1. This Constitution shall be interpreted in a manner that, A, promotes its purposes, values, and principles. B, advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights. C, permits the development of the law. And finally, most importantly, contributes to good governance. That advisory, does it help Kenya to contribute to good governance? It's going to create chaos. Mr. Speaker, I said when I was starting that as we debate this issue, let's be able to listen to each other. Because if we don't, we are going to miss the points in each other's issues, whether we agree or we don't agree. And as we speak here, Kenyans must understand that we are not arguing the way we are because of our interests as members of this House. No. We are agreeing to this because of posterity. We want this, when it goes down in the legal, political history of Kenya, it should have been said by those who come after us that members of the 12th Parliament address this issue soberly, not in their own interest. We must make it clear to the Chief Justice that he is wrong. And we must make it clear to His Excellency the President that he must not comply with that advisory. Mr. Speaker, not all is lost for this House. Because Article 261, that Honorable Tina Mola earlier on alluded to, gives us the chance, with the agreement of the Speaker, to extend the period if necessary. If we are able to garner 2/3 majority of the members of this House, all we need, Honorable Wanga or somebody else to do is to raise an amendment based on 261, extend the period, pass it by 2/3 majority, and we are home and dry, and there will be no crisis in the country. So let's not discuss this issue as if we don't know the way out. Lastly, Mr. Speaker, I'm happy that Parliamentary Service Commission has decided that the matter be contested in court. It is only there that these various contradictions will be properly elucidated and properly dealt with. I thank you, Mr. Speaker, for giving me this chance.
Naam, Shaban.
Asante sana Mheshimiwa Spika kwa kunipatia nafasi hii pia kuzungumzia swala hili ambalo ni la kikatiba na ambalo tayari limeweka nchi hii kwenye hali ya wasiwasi. Mheshimiwa Spika, katiba ya mwaka wa 2010, katiba yetu mpya, ilivyokuwa inatengenezwa ilikuwa kwa sababu ya matatizo yale ambayo tulikuwa tumeyapata wakati watu walikosana, na vile vile wananchi mara nyingi walisema kuwa yale makosa yaliyoko ni vizuri kuwa na katiba mpya. Mheshimiwa Spika, Wakenya wengi walitaka kuwa katiba mpya ije ndio mamlaka mengine yapunguzwe yaende kwenye ugatuzi, ili hapa juu tubaki tukiangalia masuala ambayo yanaweza kuendeleza hii nchi mbele, wakati ugatuzi nao pia unaendeleza kaunti zetu mbele. Mheshimiwa Spika, jambo linalonitatiza, maanake nilikuwa waziri baada ya katiba hii ilivyopitishwa mwaka 2010 mwezi wa Agosti, nilipata nafasi ya kuwa waziri wa jinsia. Na Mheshimiwa Spika, swala hili la kipengele cha 27(8), kipengele hiki kimetutatiza mno. Manake tayari kiko kwenye ukurasa wa haki zetu, na vile vile ni kuwa huwezi kukigusa kipengele hiki kama hutarudi kwenye kielelezo, yani referendum. Mheshimiwa Spika, Jambo linalonisikitisha ni kuwa mtu akipatiwa kazi ya uongozi, kuna umuhimu wa huyo mtu yoyote aliyekuwa kwenye ofisi ile aliyopatiwa ajue kuwa Kenya si kwa sababu ya mtu mmoja ama watu wawili, bali Kenya ni watu karibu milioni 50. Mheshimiwa Spika, kipengele hiki cha 27 ambacho kinatumika kuwa ni kwa nini bunge hili la kitaifa halina watu wa jinsia moja, haswa wanawake. Mheshimiwa Spika, tungependa kuona wanawake wakichaguliwa nchi hii. Lakini Wakenya wana haki, kama vile mwenzangu alivyotaja Mheshimiwa Olago Oloch, kuchagua katika kipengele cha 38, kuchagua mtu yoyote aliye jinsia ya kike ama ya kiume katika maeneo bunge 290. Mheshimiwa Spika, hatuko hapa kubahatisha. Mheshimiwa Spika, Wakenya waliamua kutuleta hapa. Na walivyotuleta sikuwa hawakujua kuwa eti kuna wanawake na wanaume hapa nchini. Mheshimiwa Spika, mara kwa mara mimi husikia watu wakitaja kuwa ni kwa nini hatufanani na Rwanda, kwa nini hatufanani na Afrika Kusini. Mheshimiwa Spika, haiwezekani, kwa sababu wale wanachaguliwa kupitia orodha ya vyama vya kisiasa. Sisi hapa Kenya kuna tofauti kubwa sana. Kupitia kipengele cha 38, Wakenya hupiga kura kuamua ni nani atakayewakilisha hapa bungeni. Mheshimiwa Spika, nilivyokuwa waziri wa jinsia, tulijaribu, tukaongea na Mheshimiwa Rais, akamtuma mkuu wa sheria kwenye mahakama kuu ili tuweze kupata njia mwafaka vile tutaweza kuongeza idadi ya kina mama hapa nchini. Wakatuelezea kuwa wanatupatia miaka 5 ili tuweze kupata njia mwafaka. Lakini vile vile mahakama kuu haikusema kinaga ubaga ya kwamba swala hili litatatuliwa vipi. Na wakataja kuwa swala hili ni lazima zipalishwe polepole ili tufikie idadi ya kina mama vile inavyotakikana. Mheshimiwa Spika, mwenzetu Mheshimiwa Otende Amolo alikuwa na bahati ya kuwa kwenye wale ambao walikuwa wataalam wa utengenezaji wa katiba. Mheshimiwa Spika, jambo ambalo hawataki kusema wazi ni kuwa waliangalia wakajua kuwa bunge la kitaifa ukisema utaongezea idadi vile wanavyofikiria, wakashindwa itawezekana vipi. Ndio ukaona kuwa kwenye kipengele cha 177 kwa ugatuzi, kwenye bunge za ugatuzi, waliamua kuweka kipengele ambacho kitaweza kuongezea jinsia hiyo nyingine kabisa. Waliweka bayana na kila mtu akisoma anajua kuwa wanapatikana vipi. Japokuwa vile vile ningependa kusema kuwa walivyoiweka vile, kipengele kile kimechezewa. Mheshimiwa Spika, huwezi kuwa tuna maeneo ya ugatuzi kwenye maeneo yetu ya bunge za ugatuzi, maeneo 1450, lakini wanaochaguliwa kupitia njia ile wanafika nafikiria wabunge wa ugatuzi karibu 800. Mheshimiwa Spika, ukiangalia mahesabu tayari yanakuchanganyisha. Mheshimiwa Spika, bila shaka kwa sababu kwenye bunge la Senate waliona kuwa wataifanya na weke kwenye kipengele cha 98 kuwa hawa kina mama ama wa jinsia nyingine watapatikana vipi. Lakini kwenye bunge la kitaifa ilishindikana. Mheshimiwa Spika, kipengele cha 27 kinasema kuwa watu wote ambao ni wa Kenya, haswa wale ambao wamepatiwa nafasi za uongozi hapa nchini, na sio wabunge peke yake ndio wako na nafasi ya uongozi. Uongozi upo katika mahakama, uongozi upo katika ofisi ya rais kupitia kwa baraza lake la mawaziri. Nafasi hizo ziko. Kipengele cha 27 kinataja kuwa sio wenye kuchaguliwa peke yake kwenye bunge la Kenya ndio lazima wawe thuluthi zisizopita 2 katika jinsia moja. Inataja hata wale wanaopatiwa kazi upande huo mwingine. Kwa hiyo mikono miwili ya kiserikali wanapatiwa kazi wawe pia wana idadi ya kutosha, hizo zisipite thuluthi 2. Mheshimiwa Spika, kwa nini iwe bunge ndio litabeba kashfa hii ambayo inatakana kubebwa na Kenya nzima? Inatakana kubebwa na uongozi wote hapa nchini. Mheshimiwa Spika, nilikuwa na wasiwasi ya kwamba siku moja tutakuja tuwe na jaji mkuu ambaye atafanya vitu bila kuuliza na kuweza kuzungumza na washikadau wote ili kuweza kuleta njia mwafaka ya kuweza kusaidia sisi kutatua tatizo hili. Mheshimiwa Spika, bunge la 11 lilijaribu sana. Bunge hili limejaribu kuwa sheria hii tutaileta vipi. Na Mheshimiwa Spika, sio rahisi, manake huwezi kulazimisha mtu kupiga kura kwa njia fulani. Alafu isitoshe, hupigi kura tu, ni lazima tufikirie upigaji wetu kura hapa. Je, unaleta faida gani ama unaleta nini hapa nchini? Kwa mfano, ukiwa tutaongezea wabunge 80, je, watakaa wapi? Huo ndio ukweli. Huo ndio ukweli wa maneno jamani. Na mficha uchi Mheshimiwa Spika hazai. Mimi napenda kulisema wazi wazi kuwa hayo yote tumeyafikiria. Ndio mimi ningependa kuona wanawake wanaongezeka. Ningependa kuona kuwa tutafute njia ya kuleta kina mama zaidi. Lakini je, Wakenya wenyewe wanatupatia hiyo njia? Tunashukuru kuwa katiba hiyo imetupatia kina mama 47 kupitia njia ya wakilishi wa kina mama. Lakini juu ya hapo, Mheshimiwa Spika, tunakumbuka hata seneti, bunge la seneti la kwanza, hakuna mama hata mmoja alikuwa amechaguliwa. Sasa hivi Wakenya wamejaribu wakaleta kina mama 3. Wakichanganya na wale 20 ambao walioko pale, unakuta bunge la seneti tayari limefikishia idadi ile inayohitajika. Shida kubwa tulioko nayo ni hapa kwenye bunge la kitaifa. Mheshimiwa Spika, nataka ndio kina mama waongezeke. Lakini je, tutaongeza kupitia kinyume na vile wananchi wanavyotaka? Tutaongeza bila kurudi kwa wananchi kuwauliza? Mheshimiwa Spika, kipengele cha 27 huwezi kukigusa bila kurudi kwa wananchi. Mheshimiwa Spika, ukweli wa mambo tuuseme. Mimi naomba Mwenyezi Mungu amguse Mheshimiwa Rais asikubaliane na jaji mkuu kwa jambo hilo ambalo amelifanya litakaloleta mtafaruku kwa nchi yetu hii tukufu. Asante sana Mheshimiwa Spika.
Member from Vita.
Thank you very much, Mr. Speaker. I want to go not necessarily against the grain. My colleagues are requesting me in the background to speak in Swahili. But Mr. Speaker, I think for the right ears to hear me, it is important that they're also going to understand what it is that I'm saying. Mr. Speaker, Article 259 of the Constitution of Kenya actually stipulates that the Constitution should be interpreted in a manner that contributes to good governance. Now, when you look at the way the CJ has interpreted this particular advisory to the President, which, by the way, Mr. Speaker, I don't know whether it is in a demeaning manner, but I'm informed that the President was sent such a heavy level of communication via email. The President actually was sent for this communication via email, Mr. Speaker. Mr. Speaker, the wording in Article 2617 and 8 uses the word shall. And I want to indulge my colleagues, Mr. Speaker, that the same words regarding shall, when you come to Article 159, Mr. Speaker, of the Constitution, in exercising judicial authority, the courts, the tribunals shall be guided by the following principles. Justice shall be done to all irrespective of status. And the question that beckons, has justice been done to all, despite the Constitution of Kenya saying that it shall? Justice shall not be delayed. How many of us here have constituents who have had cases on for years on end? The same Constitution talks justice shall be administered without undue regard to procedural technicalities. And the purpose and principles of this Constitution shall be protected and promoted. Mr. Speaker, in the same articles that talk about the judiciary, the purpose and principles of this Constitution shall be protected and promoted. It beckons to ask the Chief Justice of this country whether that has been achieved. The first article of this Constitution talks about the sovereignty of this country, where that sovereign power has been delegated to duly elected representatives. And when we try and enforce something, Mr. Speaker, then we are negating the same Constitution that we have taken an oath to uphold. And what surprises me, Mr. Speaker, is that the fifth schedule of this Constitution does not talk about just Parliament enacting laws regarding 2/3, or rather 1/3. Mr. Speaker, the fifth schedule talks about 50 laws that Parliament is to enact. 50, not 1, 50. And these as well, Mr. Speaker, there are people who have been able to take Parliament to court on these matters. Mr. Speaker, Article 27, 6 and 8, which talks about the equality and freedom from discrimination, is so clear. It states that the operative word here that is being used is the state shall ensure, not Parliament, the state. And we are now in a situation where the Constitution of this country is being read just one-sided. Mr. Speaker, I will not take much time, but I want to congratulate the Parliamentary Service Commission for the action that you have been able to take using your wisdom, Mr. Speaker. Mr. Speaker, I don't know whether the Chief Justice is not aware that Article 25C of the Constitution of Kenya gives anyone, and that be an institution or an individual, a right to a fair trial and hearing. So the question is, was this House given that opportunity? Mr. Speaker, I want us to go back again, that when we talk about shall, and there's a time lapse of 5 years, where does it say that those 5 years shall be 5 years from commencing which particular Parliament? Where does it say, Mr. Speaker, that when we are now talking about enacting, are we looking at that period from which a bill is published and we reached its pinnacle? Are we looking at 5 more parliaments to be able to come? And Mr. Speaker, previously as well, the Supreme Courts, and if with your permission, Mr. Speaker, the Supreme Court held in a majority opinion that the application of the gender rule should be progressive. This is the opinion of the Supreme Court, which was then by his predecessor, the predecessor of the current Chief Justice. So I wish to urge my colleagues, this is not an issue of just part of gender rule. When this is the one that is going to be used, there are other laws that are going to be used to tackle us. And we need to speak with one voice. We need to speak with one understanding that the principles of the Constitution are that the Constitution should be interpreted in a manner that contribute to good governance. Holding a massive election for all constituency in this country at this time and moment, is that good governance? Holding an election at this time and moment, Mr. Speaker, who is going to be able to pay for the same? Holding a mass election at a time when we all know that this country is preparing for a referendum through the BBI. And I want to tell and ask and plead with the naysayers who are against constitutional change in this country. We as Parliament need to ensure that every single thing that has affected this House are going to be enacted and changed using the BBI initiative that is upcoming and shall be before the next elections, Mr. Speaker. Mr. Speaker, with this, I beg to urge all my colleagues, this is not an issue of who was here. And I remember being with my sister Gladys here, sharing red roses, Mr. Speaker, at a time when we were trying to ensure that the two-thirds bill, but it is true equally, there are members who are not here. And as much as the men will only be seeing the women, because this is something that was touching on the one-third gender rule, I want to just remind my colleagues that when a man speaks up and speaks on behalf of a woman, it does not show his weakness. When a man speaks up and ensures that a woman's rights are defended, that shows the true quality of a man. And our job is not to put these women down. Our job is to ensure that we lift them up. Where they are wrong, we rectify each other. As much as where we are the ones who are to err, they can be able to rectify us. Thank you very much, Mr. Speaker.
Now, honourable members, there are still 43 of you who have indicated interest to contribute to this debate. And I think it will not be right for me to, I do not want to deny any of you a chance to speak. So, for the convenience of the House, and in order to allow us to go back to that, what we are debating now, I will reorganize the order paper, so that the business appearing, the following orders are made. Business appearing as order number 11 is taken out of the order paper at the request of the leader of the majority party to allow the committee to go and consider fresh proposed amendments that came in yesterday. That's all, but it will be considered on Thursday afternoon. I know the Honorable Millie Odhiambo, you are the guilty party. Not guilty in the sense that it's wrong to bring amendment, but the committee just got your amendments this morning, and they have requested that they consider. In fact, I think they should invite you so that you can go and discuss with them, so that by Thursday then you move a little faster. Also, order that order number 8 and number 10 be read out so that we dispose of them quickly.
Order number 8, the County Wards Equitable Development Bill, Senate Bill number 34 of 2018. Question to be put.
Honourable members, I can tell that the member for Emuhaya still remembers, I think, the debate. Debate on this motion was concluded, and what remained was for the question to be put, which I hereby do. That the county wants Equitable Development Bill, Senate Bill number 34 of 2018, be read a second time. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? Nay. Just a minute. Honourable members. I repeat, honourable members, I repeat, in order to get a clearer result. The county wants Equitable Development Bill, Senate Bill number 34 of 2018, be read a second time. Will as many as that opinion say aye? Will as many as for counter opinion say nay? Nay. The nays have it. Next.
Order number 9, motion, audited financial statements for the National Government Constituencies Development Fund for constituencies in Kiambu County. Question to be put.
Once again, honourable members, debate on this motion was concluded, and what remained is for the question to be put, which I put, that this House adopts the 9th report of the Special Funds Accounts Committee on the audited financial statements for the National Government Constituencies Development Fund, NGCDF, for the constituencies in Kiambu County, laid on the table of the House on Tuesday, February 25th, 2020. Will as many as of that opinion say aye? Aye. As many as the contrary opinion say no? The ayes have it. Next. Honour members, very, very briefly, very quickly, the chair of Environmental Committee. This is straight. Move your motion. Call it.
Order number 10, procedural motion, extension of period for consideration of specified petitions.
Very quickly, please.
Thank you, Mr. Speaker. Mr. Speaker, sir, I beg to move that, notwithstanding the provision of standing order number 2272, Committee of Petitions, and aware that the charges posed by the COVID pandemic in entering House committee sittings, cognizant of the request by the relevant ministries to have additional time to make submissions on the petitions before the committee, and recognizing the need to engage other stakeholders for the detailed information, this House resolves to extend the period for considerations of the public petitions by the Departmental Committee on Environment and Natural Resources specified year under by further period of 60 days. 1, public petition regarding an alleged demolition of houses and repossession of land within Langata constituency by the Honourable Nixon Kolil MP, presented on 30th June 2020. 2, public petition regarding the encroachment of Nairobi National Park, presented on 2nd July 2020. And finally, Mr. Speaker, public petition regarding mitigations of personnel or perennial flooding of River Sondu, Mliu, in Nova Bay County and Kisumu County is presented on 12th August 2020, Mr. Speaker. Mr. Speaker, we are aware of the challenges which the country is facing due to the COVID, and hence, Mr. Speaker, the Committee of Environment and Natural Resources has consulted the various relevant ministries, and due to this situation, Mr. Speaker, the various ministries have sought the committee so that they can be able to present the views within the next 30 days or thereabout, Mr. Speaker. So therefore, Mr. Speaker, that's why the committee could not be able to expedite on this particular matter, and hence we are requesting for the consideration of this House, so that the petitions can be submitted within the next 60 days. Mr. Speaker, having said that, I beg to move and call upon the Vice Chair of the Committee, Sophia Abdinul, to second the motion.
Honorable Sophia Abdi. Where is the account?
Thank you, Mr. Speaker. Mr. Speaker, I beg to second the procedural motion on extension of the period to consider petition before the Committee on Environment and Natural Resources, Mr. Speaker. Mr. Speaker, the matters that are before this committee are very heavy, and it requires a lot of public participation and a lot of stakeholders' engagement. We have so far done several, and several other stakeholders have requested the committee for time. Due to COVID, we were facing many challenges, and many times we could not be able to complete the exercise that we gave ourselves, Mr. Speaker. With that in mind, Mr. Speaker, we are asking the intelligence of the House to give us an extension of period to consider the petition by further 60 days, Mr. Speaker. I beg to second. Thank you.
Well, honourable members, I propose the question, which is that notwithstanding the provision standing on number 227, subsection 2, which is on committee of petitions, and aware of the challenges posed by the COVID-19 pandemic in hindering House committee sittings, cognizant of the request by the relevant ministries to have additional time to make submissions on the petitions before the committee, and recognizing the need to engage other stakeholders, detailed information, the House resolves to extend the period for consideration of the public petitions before the Departmental Committee on Environment and Natural Resources specified hereunder by a further period of 60 days. The public petition number 1, petition regarding an alleged demolition of houses and repossession of land within Langata constituency by the Honorable Nixon Coril, MP, presented on 30th June 2020. Number 2, public petition regarding the encroachment of Nairobi National Park, presented on 2nd of July 2020, and public petition regarding mitigation of perennial flooding by River Sondu Miriu in Homa Bay and Kisumu counties, presented on 12th of August 2020. Put the question that notwithstanding the provision of standing order number 227, subsection 2, Committee of Petitions, and aware of the challenges posed by the COVID-19 pandemic in hindering House committee sittings, cognizant of the request by the relevant ministries to have additional time to make submissions on the petitions before the committee, and recognizing the need to engage other stakeholders' detailed information, this House resolves to extend the period for consideration of the public petitions before the Departmental Committee on Environment and Natural Resources specified hereunder for a further period of 60 days. Public petition regarding the alleged demolition of houses and repossession of land within Langata constituency by the Honorable Nixon Coril, MP, presented on 30th June 2020. Number 2, public petition regarding the encroachment of Nairobi National Park, presented on 2nd of July 2020. And number 3, public petition regarding mitigation of perennial flooding by River Sondu Miriu in Homa Bay and Kisumu counties, presented on 12th of August 2020. Will as many as that opinion say aye? Aye. As many as the contrary opinion say nay. The ayes have it. With that, honourable members, we go back to the debate, which I see there's still immense interest. Let me now hear from the chair of the Justice and Legal Affairs Committee.
Thank you, Mr. Speaker. I would like first to congratulate you and members of the Parliamentary Service Commission for deciding to take this matter to court. I can assure you that we support you and expect you to get conservatory orders so that we can have sufficient time to amend the offending provision in 261. Mr. Speaker, this is a matter where a party acts in bad faith, decides to revisit what was purportedly revisited. Mr. Speaker, I would like to fault Honorable the Chief Justice as follows. Firstly, he is on what in legal parlance we call, he is in peri delicto. He himself has slumbered. He has slumbered peri delicto. He has slumbered in action. For 2 years, when this matter was taken to him, he never acted. He is now faulting Parliament that I'm dissolving you because you have not acted. When a situation like that arises, no party is entitled to take advantage. The second way to fault him is that if you look at the definition of the word advice, I took time and I called my office when I was here to give me the legal meaning of the word advice. And they went to a dictionary, eminent dictionary in law called Stroud. Stroud Legal Dictionary is an acknowledged authority on legal terms. And it says the word advice is guidance had not advised. Let me just give the proper meaning. It means guidance or recommendation of at a pin there to a client with regard to a future action. In this instance, Maraga has no client. If you draw an analogy, he has no client. He has acted unilaterally. I fought him as follows again. One, because of the experience of Wajiko, remembering that, and I'm using the name Wajiko to represent the people, spelled in Article 1. Because Wajiko had suffered through a system of impromptu elections in the former constitution, what we are calling roadside decisions, she decided that the time of elections, general elections, must be made public. And it is pronounced now in Article 101. And that is the only clause that gives leave to general election. There is no other clause in the Constitution. And when you interpret the law, one of the guidelines says that when there are two conflicting, if one were to say that the advisory note contradicts 101. Because Maraga, the import of Maraga's advisory is to dissolve the House. And 101 provides for dissolution of the House and calling general election. If you said there was a conflict, then if there are two conflicting provisions, the first one is the one which takes precedence over the other one. I start challenged by any lawyer here. The first provision, when there are two conflicting, the first provision takes precedence. So 101 is the first precedence. So if you take it that it takes precedence, then 261 sub 7, no, Maraga is he acted on 7. Yes, it goes. It flops. Then the other way, the other prong that I want to take, Maraga, is Wajiko has the sovereignty. The sovereignty of this country, the sovereignty of the country, she is the mother and father of the Constitution. And the only person who is recognized to be her attorney in matters of the Constitution is only Parliament, through her duly democratically elected representative. Would you say that Maraga is a democratically elected attorney? Because of that, Maraga cannot go and usurp 101 and decide to call for dissolve the House. I want to, again to allude to what my colleague Aruoch referred to 259. The word shall is employed in 259. 259 subarticle 1D. It says, I want to emphasize this, that whenever you are construing and interpreting the Constitution, it must be in a manner that contributes to good governance. Would you say this advisory, the effect of this advisory is going to contribute to good governance? Already, Wajiko is overburdened by COVID, by slum in the economy, and you are telling her to go for elections impromptu, spend that $1 billion, then in 2 years down the line, spend another $2 billion. 10 billion, no. Elections.
10 billion.
Yeah, it's 10 and then 10. Yeah, that was unwise. I say this with an emphatically say so. This action by the Honorable the Chief Justice demonstrates clearly that he lacks rudimentary tenets of the law. I say this with a lot of respect. I know we should not be discussing the conduct of a Chief Justice, but the matters I'm alluding to are public knowledge. He has invited it. They are, and again, he has invited it. One, I want to say, this is a Chief Justice who notoriously acquitted the Kiambaa victims when he was a High Court judge on very flimsy grounds when he was in Nakuru. Some other knowledge that you may not know. This same justice was number 4 in the interview. So I don't think it was a question of regional balancing. He had a godfather somewhere. And he is still serving. I think there is somebody who Aruoch alluded to bad faith. Looking at the way this advisory is crafted and the story behind it, you cannot slabber for 2 years and then impromptu one day wake up and say, I am now advising the president. Even the manner in which this advisory was transmitted It is now public knowledge that it was transmitted through an email. An email to His Excellency. Hiyo ni madharau. It demonstrates he was in a hurry. He was in a hurry to execute mandate at the behest of his master. Indeed, the effect of this, if it takes effect and this house is dissolved, just like a leader of my minority said, it is a mischievous way of killing the BBI. So let us in unison, my colleagues, support court action, get conservatory orders, and as soon as we can, I would request the leader of majority to guide us so that we get a bill here to amend or repeal or call it Article 261 as soon as the one with the timelines. I'm not talking about 227. I'm talking about 261, the provisions that give us afford timelines, so that once we remove that, then it becomes 27 will stay as it is until cows come, ng'ombe zirudi nyumbani. Thank you very much, Mr. Speaker, for giving me that opportunity, and hope that in future proper emphasis will be afforded to Article 259 is a guiding whether any constitution as far as the constitution is concerned. Thank you very much.
Member for Kisumu County.
Thank you, Mr. Speaker, for this opportunity. Mr. Speaker, right from the onset, I would like to say that I support Justice Maraga's action. Mr. Speaker, long before I came to this parliament, as the chairperson of Thuluthimbili Zama Akina Mama, I interacted with you on several occasions regarding this issue. Mr. Speaker, I'd like to say it out clearly that you listened to us, engaged, and helped us work through lobbying so that we would ensure that we do not get to where we are currently. And Mr. Speaker, I want to thank you for that. Mr. Speaker, as I stand up to speak, I'm not speaking as a woman. I'm speaking as a member of this Kenyan society who would wish to see the rule of law govern Kenya. Mr. Speaker, I speak as a politician who, after 12 long years of struggle, was eventually elected to come to this house. And on the day I swore, or I took, on the day I was sworn in Parliament, I swore that I would protect and uphold this Constitution. Mr. Speaker, and that is what I'm doing now. Because this is not about women. This is about the Constitution. Mr. Speaker, it does not mean that when members of Parliament fail in carrying out their mandate, that the Chief Justice also must fail. In Article 261, Mr. Speaker, the Chief Justice has the mandate to advise the President on what to do to dissolve Parliament if an issue such as this has not taken effect. Mr. Speaker, so the Chief Justice is right. Mr. Speaker, this debate is not about the character of the Chief Justice or whether the Chief Justice is trying to give the last kicks of a dying horse because he's supposed to go home. Mr. Speaker, it's about Kenya. Are we ready to allow the Constitution of Kenya to actually still be regarded as the supreme law of the land? Or, when it comes to some issues, are we ready to throw the Constitution away? That is what we are discussing. Mr. Speaker, it's getting a little hot, so I'll remove my specs. Mr. Speaker, it's not enough to say that because women, members of Parliament, do not work hard, then this should be thrown out. Who said women of members of Parliament do not work hard? Mr. Speaker, as I stand here today, I've been polled and voted in as the best woman representative in the whole country by Infotrack in the latest polling. Doesn't that show that I work hard? So, Mr. Speaker, this is not about women and women's performance. Mr. Speaker, I would like to say that indeed, when we talk about Article 100...
Now, I want to the member for Emuhaya as a point of order.
Thank you very much, Honorable Speaker. In fact, I want to bring to order and ask the member who was speaking, honorable member, and with respect, that what is this info track that he's talking about? Because we have known of fake people moving around and ranking members of parliament, and usually they are sponsored by the people who are actually get number one. So what is this, and where did you do it? Could you explain to us exactly what it is? Thank you, Honorable Speaker.
Mr. Speaker, I will not let that derail me, but if it is a problem, I take it back so that I can have an opportunity to move on. Mr. Speaker, I'd like to say that Article 27 does not in any way force citizenry to vote in a particular way. We already have a similar situation in the county assembly, and we are not saying any Kenyan is forced to vote in a particular way for members of the county assembly. But if, and only if, the voting does not adhere to Article 27, you will find that there is a mechanism to ensure that that is achieved. Mr. Speaker, that is the mechanism that this House was supposed to come up with. And that is not because Mr. Maraga failed. It is because the House failed.
Member for Nyeri Town, use your point of order.
Thank you very much, Mr. Speaker. I just wanted to ask whether the member who is speaking understands that in the county assembly, the structure that exists in the county assembly allows them to actually nominate the difference in terms of the MCAs so that to get to the 30%. Mr. Speaker, our constitution has capped the members of parliament in the constitution. So for us to do that, we would actually have to amend the constitution. Thank you very much, Mr. Speaker.
Thank you, Mr. Speaker. In effect, what the Honorable Speaker has done is actually just prove my point. What I'm saying is Article 177 already gives us that mechanism for the county assembly. And although we do not have a mechanism for National Assembly, that is what we, as members of National Assembly, were expected to come up with. Mr. Speaker,
Honorable Kaluma.
Mr. Speaker, let me rise to help and say that it is not the business of this House to make the Constitution or to amend it. The two-third gender principle springs from Article 27 of the Constitution, 27.7 in particular, which is a Bill of Rights. It's a fundamental human right provision requiring referendum under Article 255 of the Constitution. So you may wish that it were done. The question we are asking, if Kenyans did not do it, and it requires Kenyans to do, why punish Parliament for it?
Mr. Speaker, I'd like to inform the Speaker who've just spoken that, indeed, the members of the public already passed that Article 27, because it was part of the Constitution that was actually passed and promulgated in 2010. Mr. Speaker, I hear a lot of people saying, Mr. Speaker, that we must ensure that we have good governance and that the action of Mr. Maraga Justice Maraga does not promote good governance. What is good governance if it's not inclusivity? Mr. Speaker, what Maraga has done is a way to ensure that we have inclusivity, which is part of good governance. Mr. Speaker, I also hear, and I support BBI. I'm a proponent of BBI, but we will not use BBI to erode gains that are already in this Constitution. BBI is supposed to improve our lives by even enhancing inclusivity. So why would you take away the inclusivity that's already in this constitution in the name of BBI? Mr. Speaker, I know I sound angry, but the reason why I'm sounding angry is because for 12 years I fought to get here. And I cannot imagine that now once that I'm here, I am actually one of the people who cannot ensure that good governance, including inclusivity, is passed in this House. Mr. Speaker, I support Justice Maraga, and I pray that our President will be bold enough to dissolve this parliament so that we go back to the people, Mr. Speaker, and get the people's mandate again. Mr. Speaker, I would like to say that this the Article 27 or the 2/3 gender rule is the only area that has not been affected ever since this constitution was passed 10 years ago. Mr. Speaker, I am not surprised. I am not surprised going by what has been said in this House. But Mr. Speaker, I'm hopeful that if we move together, we can find a way to ensure that we solve this issue. And there is an opportunity. Mr. Speaker, I thank you.
Sorry, honourable members, let us just,
Why are you wearing Rosa with
now, Honourable Millie, again, don't become a prefect, now, Honourable Millie, the Honourable Rosa Buyu has done very well. She has made her point. And it's not even for me to even quarrel with that. She has been very eloquent. She has made her point. She doesn't even require the assistance of the Honourable Millie Odhiambo, who I'm sure is very aware of the Latin maxim, expressio unius est exclusio alterius. So, I mean, I'm sure you are aware of that. Honourable Kanini Kega.
Speaker, thank you so much, Speaker. And I beg to relax the mask a little bit. Mr. Speaker, you have completely lost us, and especially for us who are not lawyers. Mr. Speaker, I want to associate myself with most of the sentiments that have been expressed here, Mr. Speaker, and mostly with what has been said by the Honourable Junet and Honourable Chair of JLAC. Honourable Speaker, I don't want to dwell on the merits or demerits of the advice. Honourable Speaker, I want to dwell on the aspect of how that message was relayed, Mr. Speaker. Mr. Speaker, the Chief Justice of the Republic of Kenya was supposed to proceed on terminal leave last month, but he decided not to go and instead cashed the leave days. It's true. He decided not to go on leave, but decided to cash the leave days. In law, it might not have a lot of issues. But you know very clearly that the flamers of those people who came up with work ethics and all that, the reason as to why you are supposed to go on terminal, or not terminal, but on leave, even here in Parliament, we go on recess. Because we know for sure that your productivity diminishes the more you stay in a workplace without going on leave. And some of the results, Mr. Speaker, of fatigue is sometimes making irrational decisions. Mr. Speaker, I don't want to say that this could be an irrational decision. But I am saying this as the chairman of budget, because each and every day, the judiciary is, claiming every day that we are not giving them enough money. They are saying we are not giving them enough money, yet they have enough money to pay for leave days. Mr. Speaker, that one I have an issue. And it is an issue that we also need to consider. Because if you lead by example, and instead of proceeding for your leave, you decide to cash that money, and you know the salary of the Chief Justice is not 100,000, it's in millions. So for me, it's a concern. Secondly, Mr. Speaker, this House is the one that vets the Chief Justice. If he makes good his promise that he will leave by January, though he said that he will still be in charge, and in an unlikely event that this parliament is dissolved, there will be no assembly to vet the Chief Justice. In essence, it means, then of course, the Chief Justice will continue serving as the Chief Justice. Could it be a ploy to also extend his term by taking us home? But far from that, Mr. Speaker, the import of what he said means that we will go for another general election, so to speak. The lawyers might say that it is not a general election, but in essence, it is a general election. Because elections will be held in each and every polling station, in each and every stream. It calls for a budget. And to be modest, it's about 20 to 30 billion shillings. As a chairman of budget, in the budget that I've seen, there is absolutely no provision for that allocation. Absolutely no provision. So where is that money going to come from? IABC has been said here that IABC is not properly constituted. So who is going to undertake this election? Could it be that somebody somewhere wants to plunge this country into crisis? And some of these small decisions, or some of the small things that we are saying, might create crisis in the country. We took some time, myself and the chairman of JLAC, and went to the Chief Justice. And we told him, we don't want to see you again on those stairs, lamenting, you don't have money, you don't have issues here. Come to us. If you have any issue, come to us. In essence, we were telling him, even if maybe we had foreseen this kind of a situation. If he has issues with members of parliament or the National Assembly, he should also have taken time to come and see you. You are head of an institution. You are, okay, I think, and in future we will change these titles. And I think that is where the problem is. The Chief Justice is the president of the judiciary or the Supreme Court. I think those are some of the things that we need to change. Because sometimes we give ourselves titles that give you some levels. We only have one president. You are the head here and you are the chairman of the Parliamentary Service Commission. If the Chief Justice had issues, he should also, of course, also have consulted you. Secondly, he should also have consulted his other junior officers, like the other judges, because there are cases in court already, alive cases, cases that are alive, that have effect in this. So, Mr. Speaker, I want to say from where I sit, I lead malice, and I think this advisory should be taken with the contempt it deserves, and it should be ignored. But we also thank you, Mr. Speaker, for what you have done, taking that bold step and appealing to the same courts. And I believe that the High Court will declare that opinion, an opinion and null and void. Thank you, Mr. Speaker.
Member Makueni.
Thank you, Mr. Speaker, for giving me an opportunity to contribute in this very important matter. Mr. Speaker, I want to start by quoting the former Chief Justice Willie Mutunga in a recent television interview on his experiences as the Chief Justice of the country. And he stated that that particular office, the CJ's office, he actually discovered that it is very, very political. When you look at his experiences and what the current Chief Justice has done through his advisory to the President, you realize that, and from looking at it and reading it, you can read a lot of politics in that particular advisory. Having taken that decision, or him having, decided to dissolve Parliament, it has a lot of political implications in the country. It can be used for several reasons by different people to achieve different ends. But one thing which is clear out of it, Mr. Speaker, the moment you dissolve Parliament now, then you have dissolved the government. It means, whether we like it or not, without Parliament, you cannot have a budget, and therefore you can't run government, you can't run judiciary, the moment the House is absent, it's clear. And again, looking at the Constitution generally, and a lot of articles have been contributed here, I don't want to repeat them so that other members can also contribute. You must look at what is best for the country. What are the best interests for the country? And I think that's where decisions should originate. if his decision is not best for the country, looking at the current status, looking at advice like the one which has just been given by Honorable Kanini Kega, has he consulted on the budget? And therefore, as Honorable Wamalwa Tiende said, the Chief Justice is functus official, meaning the bullet has left. Once the bullet has left, we want to thank you, Mr. Speaker, that you have taken a very quick decision so that the bullet may not hit its target as desired. And going to court again, I believe, Mr. Speaker, we are going to get justice. We are going to look at the conflicting articles of the Constitution, and that the article which is most important and takes precedence is the one of the sovereignty of the people. That at the beginning and the end of it, it is the decision of the people, Mr. Speaker, and the decision of the people is clear. It has put us here for 5 years. There are many, many other articles which support that basis, so that, Mr. Speaker, we do not end up in a situation whereby you close down the country. It's really a sadist situation. It is a wrong interpretation of the law. It must be revisited in one way or another, either through review or even a constitutional application, to analyze the constitutionalities. And I think it will be important for all lawyers in this House, Mr. Speaker, having followed this debate this afternoon and having gathered a lot of ideas, we need to pass this answered to the lawyers acting on our behalf, and some of us should volunteer also to support that cause, Mr. Speaker, so that justice is done in this country, and so that there will be no ideas, because you see the president already can decide, can still make decisions if this target is not moved as you have done through the courts. And Mr. Speaker, I believe from the answer of this afternoon is so useful to the lawyers, and all ideas have been put forward, and and the best position has already come out of this. I really thank you, Mr. Speaker. We look forward to a station where our constitution, as it is currently, is followed, and that is the sovereignty of the people. I thank you, Mr. Speaker.
Thank you very much, Honorable Speaker, for giving me this opportunity to contribute in this particular motion, Honorable Speaker. Honorable Speaker, from the onset, I want to urge the House that just as we respected the nullification of the election, though most of us did not agree on it, and those who were singing up and down that we should respect the courts and the decision of Maraga, are now the ones shouting the loudest that Maraga have erred, and that we should not respect the decision of Maraga. We should respect the courts. It's an arm of government, judiciary. We are another arm of government, and the executive is another arm of government. So let us allow the president to make that particular decision, and I advise him that he should dissolve parliament so that we can go back to the people. Honorable Speaker, Honorable Speaker, Honorable Speaker, protect me from honorable members because they are shouting that I am nominated. Don't think that being nominated is very easy. I represent 6.5 million Kenyans. Some of you represent only 30,000. So don't shout here up and down. Honorable Speaker, I am specially elected. And if anything, when we go back to the people, my broken leg is still there. So I'll still table it and I'll still come here. So if you are not sure that you'll come here, don't start shouting up and down. Honorable Speaker, I'm saying this because sometimes it is us who fail, Honorable Speaker. There is an amendment I had brought in Article 27 for us to amend Article 27 to exempt the two-thirds general rule on elective position, because that totally contradicts Article 1, which places the sovereignty of our country on the citizen, who then can donate that sovereignty to the elected leaders.
Honorable Sangok, just in case that's what you have proposed, I think it's good to take free advice read Article 255 to realize that any proposed amendments to any provisions in the Bill of Rights, including Article 38(2), which was read on political rights, is a referendum matter. So don't do it within Parliament. That one, you should be collecting signatures out there. That's why even amending that word, elective, even them collecting that, so that, Honorable Sankok, is just to advise, to help you. So that now, it's a good proposal, but if you have brought it here, it is in the wrong place. It should be out there collecting signatures.
Thank you very much, Honorable Speaker. You know, you are a mobile encyclopedia when it comes to the law and the constitution of this country. So we take your advice, and I've taken your advice very cleanly, because I didn't know where it have died, because I went to the committee responsible, and I presented my case, so they never came back to me to also advise me on the same. And thank you, today I've gotten that advice. But Honorable Speaker, why are we always talking about one particular article in our constitution? Why should we allow one article to have massive impact in our governance system? Article 54 of the constitution talk of employment of persons with disability. We have not implemented that one. Honorable Speaker, the judiciary itself, it is not well constituted in terms of two-third gender rule, and it was easier from that direction. And we have never, as a house, call Maraga or call those who are responsible and even castigate them. The President, Honorable Speaker, have appointed cabinet secretaries. We know that two-third gender rule is in our constitution. Have we ever called the President and threatened him to impeach him, because we have the powers to impeach him, because he have not rightly followed our constitution? He have contradicted our constitution. We have not. So if you have not, Honorable Speaker, if you are not, Honorable Speaker, and protect me from my party majority whip, because I respect him so much, he's my friend and will remain my friend forever. Honorable Speaker, sometimes as a house we fail, because if we will have used the teeth that the constitution have given us, these other arms of government will have known that we do exist and we have the teeth to bite. Now they have the teeth to bite us. I urge them, bite us, so that the pinch will make us next parliament make sure that we also call upon them. Because why have you never, as a house, brought a motion here or a bill because of lack of gender representation in the executive? Our political parties, if you see Jubilee, the party leader is a man, the deputy party leader is a man, Secretary General is a man. We have never called them here. If you see ODM, the same. We have never called them here. We vet cabinet secretaries, and they are not properly constituted. We pass them because we rubber stamp. Honorable Speaker, let them bite us this time around, because we have failed to bite them. Na ukiamusha umbwa aliolala atakuuma. Honorable Speaker, with those very many remarks, we are now probably in the next 1 week, we shall be former members of parliament. We'll go back to the people. Thank you very much, Honorable Speaker.
Don't wish yourself that. You will not, actually. Member for Waraka.
Okay. Mr. Speaker, I thank you. I'm not going to take long, because members must speak before they rise. Mr. Speaker, this is a matter which we should not be testing our testosterone levels between the judiciary and the legislature. I wish that the people who are managing various departments of governance would have seen that the interests of the Kenyan person, the interests of we the people, is sovereign. Every decision you make, you must make knowing that what is the we the people saying. Mr. Speaker, I do not want to say so much about the Chief Justice, because So many people have said things about him, but he's a man I have a lot of respect for. But he disappointed me on this, I must say. And he knows where he is, that he has disappointed me. Because, when you are a man who has been so unscathed, and when you are just about to leave the scene and enjoy, the good name that you have enjoyed because of wise decisions, then you decide that with the one bullet that you are left with, you fire and then run. You see, it's like a king abdicating his seat. You see, because I can see what is interesting on paragraph 21 of the Honorable Chief Justice advisory. He says things which I do not know how one would ever say anything like that. Says that when he looks at the articles of the Constitution, I doubt I can read it just because I want to get something. A purposive reading of Article 261 of the Constitution leaves no doubt that the Chief Justice role under the Clause 7, therefore, is simply to ascertain if Parliament is satisfied, and it goes on. I sympathize with him. You cannot be simplistic. And even if you're simplistic, don't say it. This is not just a constitutional crisis. This is a judicial coup in the country. This group of people are the people who are between the wananchi and the governed. If today we had war, what will happen here if this chamber was not there? If today we had emergency, what will happen here if this chamber is not here? Where is that interaction between the executive and the people if it is not the legislature? And so you make a decision and you obliterate the fulcrum between wananchi and their hard-earned democratic space, and then you express yourself that my role is simply to see. How simple can you be simple? And then he says, at the end of that discourse, he says that we have to enjoy this peace together, that there is no gain without pain, and that let us have the pain together if this is going to lead us to a transformation agenda. Well, if you want to enjoy the pain, you are going on terminal leave. Go and enjoy that pain. But don't bring Kenyans as a country into this type of pain. This is not pain. This is a judicial coup. You see, the only thing I'm happy about is that he has set the stage where now everybody is now convinced, I'm sure. I don't think my colleagues, whichever shade of opinion, can now rise to think that there is anything left for somebody to convince them about referendum. There's a lot of issues we must discuss. I remember Honorable Jacomidio stood here, member for game, and said that this 20%, Mr. Speaker, we will one day have to meet eye to eye. Time has come. Time has come when now Kenyans must agree that this constitution is ripe enough for refixing so that it can be repaired. One of the things I hear about a lot, people talking about Article 27. You know, Article 27 is very interesting. I don't see anything called about gender parity in it. There is nothing. The only language I have heard there is a form of an affirmative action. There is nothing about 2/3, nothing about 1/3. In 27, there is nothing. But what is interesting about 27, it is inherently contradictory because it begins from saying every person is equal. It goes, second one, people are equal, including full and equal enjoyment of rights, including those election rights. That is how it goes. Then it says that women and men have the right to equal treatment, including the right to equal opportunities. That is what 27 says. Then the state shall not discriminate. But when you open the other side of the page, now it starts different things. And it says that the state shall not discriminate directly against any person on the basis of so many other things, and that they would be, I'm just looking for it, it was here, that there is need to give full effect. Legislative measures to give full effect, including affirmative actions, programs, and so on. Okay? Now, then you have Article 81B. That is the point. If this constitution has spoken so closely about equal rights, everybody is the same. It is a beautiful world. We were all born equal. We are all beautiful and we are all awesome. Then Article 81B starts now talking different things. It says that now some people should be elected in a different way, which is now different from what has been expressed in 27. And then we had started with Article 1, we the people. We are equal before the face of the law, and we equal before God. This is now the discussion we must make, the contradiction which the Constitution is as imposed on itself. Because, Mr. Speaker, and everybody has said, if there was an intention that there was this gender parity had to be ingrained in the Constitution, nothing would have been harder for Otiende's group and other people to say so very clearly. And this is why, for example, it has been found here, Article 101 is what kicks out the general election. Article 102 talks about term, and that term is tied to the word used there is general election. It must be a general election. Then when you go to 103, which I want to say because I didn't hear anybody saying it, 103 is the only article which talks about how a member leaves this chamber. Vacation office. And it says, how do you leave? 1, you have to die. Then 2, you have to have missed sessions of this house in 8 consecutive periods. 8, yes. Then, in the term. Then, the member, I don't know whether this is what confuses them, that the member is otherwise removed from office under this constitution or legislation enacted under Article 8.2. Now, is otherwise removed. No, this one thing which Maraga did is not remove all. It's dissolving. It's not removing anybody anywhere. You can only be removed here on chapter 6, for example. You can only be removed here if, for example, you have abdicated your responsibilities in your political party. It is removal, not dissolution. So this article here, it does not apply to what the Honorable Chief Justice is talking about. Then it says that the member resigns. You have to resign and write a letter to the Honorable the Speaker. Then you have left your political party, or you are an independent candidate, and so on and so on. Nothing in this constitution anticipates what 261 is talking about. If the drafters of the constitution wanted to see that there is a way again of vacating your office as a member, this is where they would have put it. This is where they would have put it. So, you see, I do not know how the Chief Justice, with all his wisdom, and I know he's a wise man, did not conjure up all these things together to notice that his direction under 261 was now an impossibility. He says that he only had one way. But in that way, he has also time to think through. What he didn't know, that you have time to, yes, you have one way, but you can think through, like Honorable Mutunga thought through, and decided to exempt 10th Parliament, 11th Parliament, 12th Parliament, because that advice is not implementable. As I sit down, Mr. Speaker, sir, I want to advise, well, I don't have authority to advise the president, but I know the president has very good advisors, and he will know. Just as he has read very correctly, his functions under Judicial Service Commission. You know, Judicial Service Commission says that they will take some names to him. And then the law says that he shall. But he has said so, and publicly, and I agree with him, that if these people thought that I'm just a figurehead, my duty is just to convey things, then why do you bother bringing that thing to me? Why don't you deem it, there? It means that this thing called shall means that there is a lot of things which must go through the president's mind before he does what you are calling. He is not just a figurehead, as you think, and it is the Chief Justice himself who has expressed himself that, you don't have a role, you are just a figurehead. He called him a rubber stamp. I listened to an interview where he called the president a rubber stamp. Well, if I'm a rubber stamp, why don't you come and take that rubber stamp and stamp it and go? So this is what, therefore, is equivalent to where we are here. Yes, it talks about shall, the president shall dissolve, but the president has to think about several things before doing that shall. This is when now, lawyers all over, I heard them all over say that the Constitution is clear. The Constitution is clear. They will know that there is nothing clear in this Constitution when they come to think about it. You see? Because the president, in doing this shall, now must think about several things. He has to know that the public mood now is talking about BBI to look at this Constitution, number one. He has to know that we are 18 months away to a general election, and having an election now is going to bring in these governors and even me, myself, to go for an election, to have a general election. He has to know, where do I have money to pay this? He has to think this before he does his shall. It's not that these things are not there. He has to think through them. By the time he has thought through all these things, you will discover that the word shall is indeterminate. The word shall be immediate. And even when it is immediate, it may not be now. And that is why, up to today, we don't have judges appointed. So, we are in the same country. And yes, we have been thrown to where we are. I would have wished that the Chief Justice didn't have to do this. I want to remember him more by the successes of the election petition that he properly held, in my view, the way he did. But now there is another way in which I have to think through in evaluating my understanding of him. But whichever way, let us not worry. Let us not be a parliament which looks like we are fighting an institution. It is clear in my mind, it is clear in the Constitution that I heard, and members, we need to be careful. Somebody was saying that now things that we are passing here are null and void. A very eminent lawyer. That what we are doing here are now null and void. You have not read the Constitution, because if you read the Constitution, you would know that proceedings of this House are not invalidated in any way. Even if there was something which was untoward or which was unconstitutional, still, the proceedings of this House are not a force of law and are not invalidated. So what we are doing here is we are doing what 95, 94, and 95 expects of us. Mr. Speaker, sir, I don't know why the Chief Justice had to somehow call a press conference to address the president. I've seen you several times when you have transmitted bills. Taking your place, and you are Mr. Speaker. The president is also signing, he looks very presidential. This is how it should be, because this is public service. I've never heard you call a press conference to address the president when you transmit bills to the president. So how can it be that a head of an institution so serious as judiciary must choose social media? I don't know whether email is also social media, wasn't it? Why should he choose social media to address the president and the nation? At worst, if he cannot get appointment to State House, he could have organized his brief nicely and sent to the head of service at the gate of State House and say that, give Mr. President when he comes. Or let him stand there and let us see if the president will turn him away to transmit his views. I found that he got into judicial activism, which I don't know Maraga for. Maraga is a judge of the Honorable Mutunga would have been a different cat. But remember, he's the one who dissented in that opinion about this because he knew the impossibility of implementing this kind of thing. Mr. Speaker, thank you. And I want to suggest that our colleagues on the other agenda should suffer us a little bit. If I give you an example, let me use an example from this gender that ate the apple, the forbidden fruit in the Bible. Let me take this gender. The other gender will give me a lot of problems if I took them. If we went by what is being said and increased the 290, we will have 100 people in this house, for example, men, assuming that it was men who are agitating for this gender. We will be having 100 more men in this house. Now, all these 100 people in this house would have a vote. So you are here 290, making a decision because you have the power from the people, but there are 100 more people there who are from nowhere and busybodies and have more power than you have. Yeah, like, well, in the other house, it's even protected by the Constitution because the delegation head has the vote, you see? So how can you implement this kind of thing by bringing 100 people here, and then you give them weight, and then these people now become the deciders of issues, and people who have been elected cannot have the same, Mr. Speaker, I beg to sit down. I thank you so much for giving me the opportunity.
Now, there's very little time left. 1 minute for the Honorable Wanga.
Thank you, Honorable Speaker. Honorable Speaker, now that you've said it's 1 minute, I'll just also consume the 1 minute. But I want to say that the Chief Justice only relied on Article 261 rather than looking at the Constitution holistic. Honorable Speaker, Article 261, as it is written, and as it is also stated elsewhere in the same Constitution, that where a language maybe is a challenge, the way you have said certain Latin or legal jargon, English suffices, Honorable Speaker. That's what our Constitution says. I've read it in English, and what I make of this Constitution, Honorable Speaker, you have also to look at the numbers perspective of it. Don't just look at the letters and make a decision. Article 97, Honorable Speaker, gives the numbers of the National Assembly. Article 98, Honorable Speaker, gives us the numbers that is made up of the Senate, Honorable Speaker. When you look at the numbering of the Constitution, the way you put them together to come up with the numbers, Honorable Speaker, it definitely now means for you to implement Article 261, you have to simulate a model, Honorable Speaker, through which you are going to achieve the gender rule as per what Article 27, not 261, Honorable Speaker, Article 27 envisages. Therefore, Honorable Speaker, what I'm looking at the Chief Justice as doing is trying to maybe, without really being very specific, could be he has some revenge. Could be he's trying to look at an issue which he would want to express that is not visible. Honorable Speaker, maybe he could be looking at a challenge of maybe the appointment of judges, Honorable Speaker. And I want to say so because he appeared before JLAC, where I'm a member, Honorable Speaker. And Honorable Speaker, his perception on how the judges have not been appointed and his exit, Honorable Speaker, from the judiciary, he left a mark in us as a committee in terms of how he feels of the frustration he's going through. Therefore, Honorable Speaker, I feel that his decision is vindicated.
Sorry, Honorable members, even before we rise, I want to make it clear, because I think I heard some of you say we must respect the judiciary. we are not at war with the judiciary. I think that must be made absolutely clear. We don't have a war with the judiciary. We're just dealing with this one aspect, not a war with the judiciary. So it must not go out there that we spent the afternoon discussing or debating about the judiciary. No, it isn't the judiciary. Honourable members, time there being 1 minute past 7, the House stands adjourned until Thursday, 24th September 2020 at 10 a.m.